May I have your lordship's kind leave to mention a matter, my lord. It was on last Thursday. It was item number 12 on the request of the advocate of the judge award debtor. It was meant not today. It's not appearing this week, my lord.
Not there in the list.
Not there in the list.
Next Thursday.
Well, let it appear next. I mean, let it appear next week. Next Thursday.
May I have your lordship's kind leave, my lord, to mention a section 34 application. My lord, it's been pending for some time. I'll be very candid with your lordship. No pressing urgency. If some precedence could be given.
Award of which year?
Award of 2010, but it's been pending. The execution, my lord, was appearing lately. We've been appearing. The pleadings are complete.
34 is, I'm going to keep the commercial and the non-commercial in 2 days. We'll see how it
Very
is.
well. I'll just,
Okay,
if
but-
some precedence can be given. Grateful, my lord.
I appear for the award data.
In view of the foregoing, this court is not inclined at this stage to treat the award as a validly delivered award within the meaning of Section 31(5) of the Arbitration Conciliation Act 1996, and consequently the instant execution petition, being premature, cannot proceed further in its present form. Liberty is granted to both the parties to approach the WBMSE Facilitation Council for obtaining a duly signed copy of the award or a copy bearing reproduction of the signatures of the arbitrator, duly verified, certified as such in compliance with Section 31(5) of the Arbitration Conciliation Act. Accordingly, the present petition is dismissed as premature at this stage with the aforesaid report. Pending application, if any, stands dismissed. Just check the name of the lawyers and all. Don't come back with the correction. Yes. Both the sides, huh? Check both the sides.
You mentioned item number 2.
My lord, in this matter, we appeal for the petitioner, my lord. We have received the instruction from the client to withdraw the execution proceeding, my lord, as it was a unilateral arbitration proceeding.
Learned counsel for the petitioner seeks to withdraw the present execution petition with liberty to file appropriate proceedings in accordance with law. Unilateral wala बोल रहा है ना?
And
भाई the order is unilateral.
my lord, give us liberty to appraise. my
Just
lord.
as withdraw with liberty as to. But वो appropriate में. Okay, item 1, 2, and 3 same.
No, my lord. Point two, my lord.
Only 2.
Publish, my lord.
Not 3.
Yes, Mr.
Matter is
Tata.
appearing at my instance.
Yes.
When your lordship remembers, I had taken out a EC in a wrong arbitration petition. There is a section 11 petition written. Leave was sought.
Yes. ये इस पे ये कर देना. In view of the present petition stand dismissed and withdrawn with liberty as prayed for.
Steep left. Steep left.
There is no correction required.
No, what else? What else? It's right. No. For the award holder, award debtor is wrong.
ঠিক আছে I did not know it will be who has the award.
What?
Very much. that execution case in respect of person and property both outside jurisdiction. Mr. Gupta was there, my lord.
Let me, my lord, address your lordship. My lord, if your lordship will please, my lord, see, my lord, what we are seeking execution of at the first instance. My lord, there is an arbitral award. My lord, the award starts at page 16.
Yes.
Let may I request your lordship to kindly come to page 16 once. Well,
Okay.
this is the award.
Page 16.
1-6. Well, I'll not trouble your lordship with the rest of the award. I'll straight away request your lordship now to come to page 86, which is the operative part of the award. Starts at page 16, operative part is at page 86. Well, may I just read it? Well, this was really an action for specific performance. Well, this is what the arbitrator says. I grant specific performance of the MOU dated such and such at a modified price of 155 crores as determined herein before. The claimants are directed to complete the transaction within a period of 3 months from date. The respondent sellers would be obliged to execute the conveyance in favor of the buyers or claimants as and when asked for upon receipt of the consideration of 155 crores. Despite offering 155 crores by the claimants' buyers, if the respondents refuse to execute the conveyance, the claimants would be entitled to execute the award as a decree by getting it executed through an appropriate court of law having jurisdiction to entertain the same upon deposit of the entire sum. So, the first part is with regard to execution of the conveyance against payment of 150. Now, if they don't accept it, please see now the fourth paragraph of the page. In case of default by the claimant's buyers, to offer payment of 155 crores. That is, in case they don't pay us this 155 crores and receive the conveyance.
Remember this.
Within 3 months from date.
Mr. Gupta
The MOU.
Yes, my lord, I was there. Yes.
Yes.
Yes. Well, this is the default provision. In case of default by the claimants or buyers to offer payment of 155 crores within 3 months from date, MOU would stand terminated. Now, 3 months has gone, MOU stands terminated. And the respondents would refund the amount of 6.2 crores along with simple interest at the rate of 5% per annum from the date of such refusal until realization. So, whatever advance was paid to us, we have to give that back with interest. Now, this is the portion that survives because now, by operation of the time frame stipulated in the award, the first part is now MOU stands terminated. Now, we have to give back this money. We are making this application only for enforcement of this part of the award. Now, this falls under Order 21, Rule 1, mode of payment of money into court. Now, if your lordship will please see, what am I seeking? Now, please come to the tabular statement. That your lordship will find at page 2. An award directing enforcement and implementation of an order directing enforcement and implementation of the award dated 25th November 2025, and B is important. An order directing and permitting the petitioners to deposit before this honorable court the sum of rupees 6 crores 21 lakhs 18,904 or such further sum as may be deposited. Upon such deposit, order recording full and final satisfaction. Now, this we are really seeking, in terms of the provisions of Order 21, Rule 1. May I request your lordship to kindly have a look at this. We want to pay the money into court, nothing more than that.
Order?
Order 21, Rule 1. Modes of paying money under a decree.
Yes.
Modes of paying money under a decree. All money payable under a decree shall be paid as follows. We are concerned with A and C. By deposit into the court whose duty it is to execute the decree, or sent to the court by postal money order or through a bank, or C. Otherwise as the court which made the decree directs. Otherwise as the court which made the decree directs. Now, important is, now my learned friends are saying that this court will not have jurisdiction. Now, so far as jurisdiction is concerned, the arbitral proceeding was held in Kolkata. Rounds of litigations up to the Supreme Court, they tried to, have the seat of arbitration in Jaipur. That was not allowed. Ultimately, the matters by Supreme Court's orders came to Kolkata. sittings held in Kolkata, award passed in Kolkata. So, my lord, the arbitral seat was in Kolkata. Now, my lord, that makes it, my lord, this court, the court which passed the decree. My lord, please have a look at, my lord, two more sections only, sections 38 and 39 of the Civil Procedure Code.
Yes.
Well, 37 is, my lord, the definition of court which passed a decree. My lord, this is, of course, my lord, in the context of a suit. But, my lord, now, my lord, since the award has been passed in Kolkata, arbitral sittings held in Kolkata, seat in Kolkata, well, the court, my lord, by which the decree may be executed will be the courts in Kolkata. Well, 38 is very important. A decree may be executed either by the court which passed it or by the court to which it is sent for execution. Now, my lord, either by a court which passed it. My lord, that is the first thing. Then, my lord, transfer of a decree, that's section 39. The court which passed a decree may, on the application of the decree holder, send it for execution to another court. And then, my lord, what are the circumstances? A, if a person against whom the decree is passed actually voluntarily resides, so on and so forth. My lord, these four, my lord, criteria are provided. And then, my lord, this is the amendment for 2022. My lord, that is subsection 4. Nothing in this section shall be deemed to authorize the court which passed a decree to execute such decree against any person or property outside the local limits of its jurisdiction. So, my lord, your lordship can execute the decree as the, my lord, quote under section 38, except when, my lord, the execution of the decree is sought against, my lord, person or against property outside. Now, my lord, we are not seeking execution against person or against property. All that we are seeking is, my lord, direction to pay into court. Now, my lord, the question is, my lord, whether in such circumstances my learned friend can oppose, my lord, my execution petition on the ground that, my lord, today your lordship lacks jurisdiction to entertain it. That is the short question. Now, my lord, so far as this is concerned, the language of section 38 is very important because the court which passed the decree can execute it. The only, my lord, fetter on its jurisdiction is, my lord, when the execution is sought against a person or against property outside the jurisdiction. Now, my lord, if I am not seeking execution against a person who is outside the jurisdiction or against a property outside the jurisdiction, can I do it?
Yes.
My lord, I think, my lord, the language of the sections is quite clear. But, my lord, just to, my lord, fortify my arguments with, my lord, some judgments, my lord, may I just show you, lordship? Salim advocates for association to the. My lord, very short portions of a couple of judgments, my lord. My lord, this is 2005, volume 6, Supreme Court cases 344. My lord, just paragraphs 22 to 24.
Para?
22 to 24. Well, this your lordship will find at page 365. Or, my lord, I'm sorry, my lord, internal page
Page?
28. 28.
Yes.
Section 39(1) of the code provides that the court which passed a decree may, on the application of the decree holder, send it for execution to another court of competent jurisdiction. By Act 22 of 2002, Section 39(4) has been inserted, providing that nothing in the section shall be deemed to authorize the court which passed a decree to execute such decree against any person or property outside the local limits of its jurisdiction. The question is whether this newly added provision prohibits the executing court from executing a decree against a person or property outside its jurisdiction, and whether this provision overrides Order 21 Rule 3 and Order 21 Rule 48, or whether these provisions continue to be an exception to Section 39(4), as was the legal position before the amendment. Well, we are talking in the context of Order 21 Rule 3 and Rule 48 here. Order 21 Rule 3 provides that where immovable property forms one estate or tenure situate within the local limits of the jurisdiction of two or more courts, any one of such courts may attach and sell the entire estate or tenure. Likewise, Order 21 Rule 48, attachment of salary of a government servant, railway servant, or servant of local authority can be made by the court, whether the judgment debtor or the disbursing officer is or is not within the local limits of the court's jurisdiction. Section 39 does not authorize the court to execute the decree outside its jurisdiction, but it does not dilute the other provisions giving such power on compliance with the conditions stipulated in those provisions. Thus, the provisions of Order 21 Rule 3 or Order 21 Rule 48, which provide differently, would not affect be affected by section 39, subsection 4 of the code. Well, we are not concerned with Order 21, Rule 3 or 2048. We are concerned with Order 21, Rule 1. But if your lordship finds that this does not involve execution of the decree against a person or a property situate outside, then, my lord, Order 13 and Rule 4 does not really come into play. My lord, this is, my lord, one judgment, and, my lord, similarly, my lord, there's another judgment, my lord, of our High Court. My lord, this is in Birla Corporation. My lord, here again, I'll show your lordship only one paragraph, paragraph 24. No, this is, I'm sorry, my lord, this is the Bombay High Court. Sorry. Sorry. Kindly give me a moment, my lord. Huh? Birla Corporation. No, Birla Corporation. Kindly give me a moment. I have mixed up my. Yes, my lord, paragraph 24. Well, your lordship may, my lord, skip the first part of this paragraph because this deals with the, my lord, clause 13, my lord, jurisdiction of, my lord, the High Court, Chartered High Courts, my lord, under the Government of India Act, etc. Then, if your lordship kindly sees, my lord, the last, my lord, 10 lines. This practice and procedure adopted by the said rule cannot be taken away and or be curtailed by subsection 4 of section 39 of the said act by the parliament, and can only be done by the full court. Now, this portion. Moreover, subsection 4 has to be read in the context of the parent provision of section 39. Section 39 of the Code of Civil Procedure has already been explained by a division bench judgment of this court, as quoted above, as being the power of discretion. Power of execution of a decree is primarily derived from the provision of section 38. Therefore, sections 38 and 39 have to be read conjointly and has to be given the objective meaning. The duty of the court, while interpreting any portion of the statute or any section of a statute, would be to give harmonious meaning so that the primary object of the section is not rendered nugatory by amended provision. According to me, the word shall mentioned in subsection 4 of section 39 is not intended to mean as being mandatory, for it cannot be read inconsistently with subsection 1 of section 39. It is the discretion of the court either to execute by itself or to send it. But the legislature has advisedly provided, in case of the situation as mentioned under subsection 4, that the court which has passed the decree will not ordinarily execute by itself if it is found that the execution is possible legally and conveniently on the decree being sent to the appropriate court within whose jurisdiction the property situates and the person resides. This does not mean that the court's discretionary power in a fit and proper case is curtailed to execute by itself, even in case as mentioned in subsection 4 of section 39 of the code. If this provision is read as being mandatory, then the unscrupulous judgment debtor who is sought to be executed will go on changing his place of residence, etc. My lord, this is not important. So, my lord, it is a discretion. And, my lord, your lordship has to, my lord, find as to whether, my lord, the convenience, my lord, of the situation would allow, my lord, another court to execute the decree. And, my lord, obviously, the operative part of section 39, subsection 4 is if the decree is sought to be executed against, my lord, a property outside jurisdiction or against a person outside jurisdiction. Well, we are seeking neither. And, my lord, one last judgment, my lord, also of now this is, my lord, 2016. My lord, division bench of our High Court. My lord, this, my lord, with the greatest of respect, my lord, also, my lord, delved on, my lord, the section 42 aspect. As to as one court, my lord, entertains an application under the Arbitration Act, whether all applications will have to be filed there. I will not trouble your lordship with that part of it. Let please see paragraph 4 first. Some of the relevant provisions of the Civil Procedure Code relating to execution of decree are set out below. Then 38, 39 are, my lord, extracted. Then, my lord, please see paragraph 5. The appellants filed an application being EC number such and such in this court for enforcement of the award made and published on 11th March 2008. By an order dated 16 September 2009 in EC such and such, the Honorable Single Bench directed the receiver appointed in AP such and such to take physical possession. Then paragraph 8. The question which arises for consideration in misappeal is whether this court is the appropriate court of competent jurisdiction to enforce an arbitral award under the 1996 Act. Related to this issue is the issue of whether an execution application is required to be transferred to another court in terms of Section 39 of the Code of Civil Procedure, even if the award holder is seeking examination of the judgment debtor. A question which follows from the aforesaid issues is whether the expression property in Section 39 of the Code of Civil Procedure is to be interpreted as immovable property or whether the expression includes movable property. Now, my lord, I'll request your lordship now to straight away come to paragraph 43. Or, my lord, may I request your lordship to please see paragraph 39 once.
Yes.
My lord, this is, my lord, a Delhi High Court judgment, my lord, paragraph 39. My lord, in which section 42 is, my lord, discussed. Section 42 is to exclude jurisdiction of different courts, etc. Then, my lord, paragraph 40. My lord, this is, my lord, Supreme Court Mohit Bhargav, 2007 4 SCC. The Supreme Court held that there cannot be any dispute over the proposition that the court which passed the decree is entitled to execute the decree. This is clear from section 38 of the code, which provides that the decree may be executed either by the court which passed it or by the court to which it is sent for execution. However, a decree could be executed by the court which passed the decree so long as it is confined to the assets within its own jurisdiction, or as authorized by Order 21 Rule 3 or Order 21 Rule 48 of the Code, if the judgment debtor was within its jurisdiction, or if the decree was for personal opinions by the judgment debtor. However, after the amendment of the Code of Civil Procedure with effect from 1st July 2002 by incorporation of subsection 4 of section 39, it might not be possible to accept the contention that it was a matter of discretion for the court either to proceed with the execution of the decree or to transfer it for execution within the jurisdiction. Now, please see 43. An execution against immovable property lying outside the jurisdiction of the executing court is possible in terms of Order 21, Rule 3 of the Code, which governs a case where the particular immovable property forms one estate or tenure within the local limits of the jurisdiction of two or more courts, and where all those courts is approached for execution of the decree against that property. In a case where Order 21, Rule 3 has no application, the position is that if a decree holder wants to proceed against the property situated outside the jurisdiction of the court which passed the decree, he has to get the decree transferred to the appropriate court for execution on moving the executing court in that behalf. In our view, Order 21, Rule 50 applies only to immovable property and not to movable property, cash, etc., which would not necessarily be situated within the territory of any one court, but could be moved from one place to another. When execution is sought against movable property, the question of transfer of decree or award cannot arise, since the location of movable property cannot be determined with certainty, and the same may be moved by the judgment debtor from jurisdiction to jurisdiction. Furthermore, in an age of computerization, the bank accounts are not necessarily operated at a single branch. Net banking enables a customer of a bank to transfer funds from any place. In this context, it may perhaps be pertinent to note that most banks have their main operations in a single branch, particularly some nationalized banks, and even checkbooks, when requisitioned, are not supplied by the branch in which the account is held, but are sent from different branch, which could be in a different state by reason of the centralized operation. Similarly, payments for use of credit cards are ultimately remitted to a particular branch in a particular city where centralized operations are carried on. Examination of a judgment debtor under Order 21, Rule 41 is resorted to when the award holder is not aware of the assets and properties of the judgment debtor, which might be available for satisfaction of the award. The judgment debtor is examined to ascertain what properties or means the judgment debtor has of satisfying the award. The situs of the assets and properties of the judgment debtor can only be ascertained after examination of the judgment debtor. The question of transfer to a court having jurisdiction over the properties of the judgment debtor could not arise at this stage of examination of the judgment debtor. The proposition finds support from the judgment of this court in DVM construction. But all that I'm trying to, my lord, assert before your lordship is that, my lord, where your lordship finds that, my lord, section 39(4) is attracted, where the execution is sought to be, my lord, levied against a person or a property outside the state, or outside the jurisdiction of the court? Most certainly. Well, a transfer, because well, I am also of the view that after 2002, well, the discretion is not available. It has to go. But my lord, where well, there is nothing to my lord, there is no execution sought against the person or property, my lord, the question of transfer will not arise. My lord, section 38 is invoked. Court which passed the decree has the jurisdiction. Your lordship does not lack jurisdiction in that regard. My learned friend also said it should be transferred because the property which is the subject matter of arbitration was in Jaipur. And well, it also said that, my lord, this, my lord, now, had it been the case of, my lord, seeking execution of the conveyance, etc., then, my lord, that would have been a different matter. But, my lord, that stage is gone. In terms of the award, my lord, that part is over. I have to now, my lord, make a deposit. Well, I want to make the deposit before your lordship. My lord, I had offered this money to my learned friends, they refused to accept it. Hence, I had to approach your lordship's court. Well, lord, that is all I have to say in this.
Yes, Shankar. What is the difficulty? Why can't they do it here?
Now, the entire argument proceeds on the premise that it is this honorable court which has passed the decree. The entire argument
Yeah,
proceeds.
what is citus of the arbitration proceeding was here? The award was passed here, right?
Yes. Now, my lord, may I trouble your lordship with a decision of the Supreme Court which is made after all these decisions have been made, which are cited by my learned
But
friend.
to what extent?
To the
39
extent it
court-
says that award is a decree by deeming fiction. It is not a decree by an order of court. There is no court which has made the award into a decree. Therefore, there is no court which has passed a decree in case there is an award which has not been set aside.
Justice Call's judgment.
2018. All the decisions which have been cited before your lordship are prior to 2018, and the entire argument is that it is this court which has passed the decree. Kindly come to Placitum, the head note B at page 7, internal page 7.
The award is to be treated as a decree. It's not like this court has passed the decree.
It is the whole argument. It is this court which has passed. My lord, kindly bear with me.
It is in this jurisdiction where the arbitral proceedings were held and
Yes.
the award has been passed.
Yes.
So that is how it is assumed that a decree has been passed from this court. That is what the argument.
Yes, so that is what I want to tell your lordship, that there is no assumption that there's a decree made by this court. This is not tenable in law. This argument that the decree is deemed to have been passed by this court, the Supreme Court says no, decree is not deemed to have been passed by this court.
Let us forget the word decree. Let us go on the word
Yes.
award.
It's not made by this court.
Right? The award is passed here.
Yes.
Right? There's no immovable property which is involved here.
Yeah.
Right? The only thing which he's seeking is the deposit of the money.
Yes.
They have offered you, you have refused.
Yes.
Why have you refused? In terms of the award, you should take it.
I should take it. I
Then-
filed a section 34, which is pending. There is no stay. I filed a stay, which is also pending. There's no stay.
Right.
Point is, my lord, whether this honorable court has the subject matter jurisdiction to receive this application qua me, whether I can be sued in this jurisdiction. That is the short point. Kindly have B of this judgment, please, my lord.
Page?
Internal page 7. The number is at the top.
Yes.
An award is, this is the conclusion. I'll show your lordship how the court comes to this conclusion. They've set the conclusion out in the heading itself. An award is to be enforced in accordance with the provisions of the said code in the same manner as if it were a decree of the court as per section 36 of the said act, does not imply that the award is a decree of a particular court and it is only a fiction. Thus, the award can be filed for execution before the court where the assets of the judgment debtor are located. The entire argument of my learned friend proceeds on the premise that this court has passed the decree. Therefore, this is the court of first instance where this decree can be executed. This is after considering, kindly come to paragraph 6 at page 10. After considering all the decisions of the high courts which were there on the subject, the Supreme Court lays down its view in paragraph 6. Considers first the provisions of Civil Procedure Code, then kindly come to paragraph 10. The relevance of the aforesaid provision, that is the provision of precepts which provides for transfer. The relevance of the aforesaid provision is that the application of the decree holder is made to the court which passed the decree, which issues the precepts to any other court competent to execute the said decree. As noticed, the expression, the court which passed the decree, is as per section 37 of the Civil Procedure Code. We may note at this stage itself that in the case of an award, there is no decree passed, but the award itself is executed as a decree by fiction. The provisions of the said Act traverse a different path from the Arbitration Act 1940, which required an award to be filed in a court and a decree to be passed thereon, whereupon it would be executable. So the award is deemed to be a decree by reason of the provisions of the Act itself, that is Section 36. By legal fiction, the court does not stamp it as a decree. It is not a decree passed by any particular court, and this is conclusively stated. Now, my lord, your lordship sees the Supreme Court considers Order 21. Kindly come to, my lord, paragraph 14 now, where enforcement or under the Arbitration Act is dealt with. Then 15 defines what is the code. So this is the judgment, my lord, which conclusively deals with the matter, not with respect to other judgments which have been shown. This is the subsequent judgment on the point in issue. So enforcement, then definition of 2E, then kindly come to 16, please. The entire argument which is made. The line of reasoning supporting the award to be filed in a so-called court of competent jurisdiction and then to obtain a transfer of the decree is primarily based on the jurisdiction clause found in section 42. This is where one court entertains. Now kindly see 17. However, what has been lost sight of is section 32 of the Act, which reads as under: termination of proceedings. Arbitral proceedings shall be terminated by the final award. So Supreme Court now considers section 42 in the light of section 32. Then come to, kindly have, my lord, the aforesaid provision at the next page. The aforesaid provision provides for arbitral proceedings to be terminated by the final arbitral award. Thus, when an award is already made, of which execution is sought, the arbitral proceedings already stand terminated on the making of the final award. That it is not appreciated how section 42 of the Act, which deals with the jurisdiction in respect of arbitral proceedings, would have any relevance. It does appear that the provisions of the said code and the said Act have been mixed up. Then kindly see, it is in the aforesaid context that the view adopted by the Delhi High Court records that 42 of the Act would not apply to an execution application, which is not an arbitral proceeding, and that section 38 of the Act would apply to a decree passed by the court, while in the case of an award, no court has passed the decree. The Supreme Court approves the decision of the Delhi High Court, further approves the decision of the Madras High Court. Madras High Court in Kotak Mahindra versus so-and-so referred to section 46 of the code, which spoke of precept but stopped at that. In the context of the code, thus the view adopted is that the decree of a civil court is liable to be executed primarily by the court which passes the decree, but where an execution application has to be filed at the first instance. That is the court which makes the decree entertains. Now kindly see the difference. An award under section 36 of the Act is equated to a decree of the court for the purpose of execution and only for that purpose. Thus, it was rightly observed that while an award passed by the arbitral tribunal is deemed to be a decree under section 36 of the Act, there was no deeming fiction anywhere to hold that the court within whose jurisdiction the arbitral award was passed should be taken to be the court which passed the decree. The said Act actually transcends all territorial barriers. So this is, with the greatest of respect, not the court which passed the decree. This court lacks subject matter jurisdiction to entertain this application.
It can be filed anywhere, Mr.
It can be filed anywhere, but not
It
here.
cannot be filed here.
Yes, it cannot be filed here because I am not situated within the jurisdiction of this court.
So what,
It
the proceedings-
seeks,
the
beg your
proceedings
pardon,
took place in this jurisdiction.
yes, that is because the seat of arbitration was here.
That's
Once the arbitration stands concluded, 42 has no application. This court will entertain this proceeding, in my respectful submission, only if the judgment debtor is within jurisdiction or the property is within jurisdiction. In this case, the judgment debtor against whom
Where do you get that from?
Order 21 now. Kindly have Order 21, which my learned friend relies on, and Section 30. Now, may I show your lordship, my lord? He showed your lordship, my lord. Salem. Now, this issue came up. Salem was also considered in a subsequent decision. 2007, 4 SC. Salem does not say anything. Kindly have Salem. Has no manner of application in the facts of our case. Kindly see Salim and how Salim has been considered by the Supreme Court in a subsequent judgment and the law is settled. May I just show your Lordship the subsequent and not waste your time, Lordship's time with Salim. Kindly have 2004 7 SCC 795. 2007 4 SCC 795. Salim was 2005. This is 2007 after considering Salim and relying on Salim, explaining what Salim says. Kindly have paragraph. Kindly have paragraph 7, please. The entire argument is premised that this is the court which passed the decree, which the Supreme Court says this is not the court which passes any decree. Now, kindly see 7. There cannot be any dispute over the proposition that the court which passed the decree is entitled to execute the decree. This does not apply in our case for the first time. This is clear from section 38 of the code, which provides that a decree may be executed either by the court which passed it or by the court to which it is sent for execution. Section 42 of the code indicates that the transferee court to which the decree is transferred for execution will have the same powers in executing the decree as it has been passed by itself. A decree could be executed by the court which passed the decree so long as it confined to the assets within its own jurisdiction or is authorized by Order 21 Rule 3. That is where there are more than one assets, one is within, one is outside. Or 2148 of the code. Now kindly see, my lord. Or the judgment debtor is within its jurisdiction. If it is a decree for personal obedience by the judgment debtor, so where he sues me and to have a certificate from your lordship that this is satisfaction of the decree qua me, I have to be within jurisdiction. When the property sought to be proceeded against is outside the jurisdiction of the court which passed the decree acting as the executing court, there was a conflict of views earlier, some taking the view approach for execution can proceed with execution but could only transmit the decree to the court having jurisdiction. Some other courts taking the view is a matter of discretion for the executing court, and it could either proceed with the execution or send the decree for execution to another court. This is the view of my Lord Justice Sengupta of our court also, which is prior to this judgment. But this conflict was set at rest by Amendment Act 22 of 2002 with effect by adopting the position that if the execution is sought to be proceeded against, now my lord kindly see, against any person or property outside the local limits of jurisdiction of the executing court, nothing in section 39 of the code shall be deemed to authorize the court to proceed with the execution. In the light of this, it may not be possible to accept the contention that it is a matter of discretion for the court either to proceed with the execution of the decree or to transfer it for execution to the court within the jurisdiction of which the property is situated. There is no discretion. Then the next paragraph deals with immovable property. But I am resting my case on paragraph 7. If a decree is sought to be enforced by personal obedience, then the judgment debtor must be within jurisdiction. Kindly have normally this case.
Mr. Saad, then I'll allow him to file his reply.
Very well.
Let him file his reply, then we'll take it up.
Yes.
Very well.
Because just on the basis of these arguments, I can't decide the.
No, very well, my lord. My lord, if your lordship, my lord, makes it short, my lord, reply. Because, my lord, he is only in a question of law.
Give me 2 weeks, my lord. Had they been in Calcutta, we would have done it earlier.
Present petition has been filed seeking execution of the award dated. What is the date of the award?
My lord, the 25th November 2025.
25th November 2025. Full stop. At the threshold, learned senior counsel for the award debtor. Learned senior counsel, Mr. Thakkar, for the award debtor, states that the present petition is not maintainable since the award debtor does not reside within the territorial jurisdiction of the court. Full stop. He seeks and is granted 2 weeks' time to file his affidavit in opposition, reply to the same if any within 1 week thereafter, list after 4 weeks.
My lord.
Grateful. Deeply obliged.
We can decide it only after exchange of affidavits.
Deeply obliged.
But I still feel, Mr. Thakkar, that I don't know. I mean, this is just first brush. That it can be filed because this is slightly different in terms of the execution of the award. This is
follow.
not regarding execution of a immovable property or any property which is involved. The award is to the extent that in case the conveyance deed is not
Yes.
executed,
I get
then
the
in
money
that
back.
scenario you get the money back, whatever by the respondents. So it is only to the extent of securing you, and I don't know why you're not taking the money.
My lord, that would render my 34 in.
He wants the property, but he doesn't want to pay 155 crores.
Okay, the deal was at 40 crores. Now the learned arbitrator has awarded 155 crores after holding that my learned friend is in breach.
So your 34, till the time your 34 is not decided.
Yes.
If you take the money also, that doesn't mean your 34 goes.
Well, it might be because that is prayer B. That is the dangerous part. It to record satisfaction of the award. So once your lordship records satisfaction of the award qua me, because it can only be qua me. Once that is recorded, that's the end of the matter.
That I
The
would not have
34
been
is-
able to do.
Assume that I take your argument.
Please, my lord.
This is not the court. They go to Jaipur.
They go to Jaipur.
They do the same thing. Then in that case also, what happens to your 34?
I resist that. I press my 34 and bring it. But here, my lord, it's
Till the time you don't really have any stay on the.
I
person
follow.
stay.
My lord, that is the basic difficulty in my case. The execution will be levied there.
Even if we assume that this is not the court of
Yes.
jurisdiction, the same issue will arise
Yes,
there
yes.
also.
Your lordship is absolutely correct. But that court would have the jurisdiction to pass that order of certificate
That
But not
my
in
lord.
execution.
No, my lord.
in Jaipur.
34 is not maintainable in Jaipur.
34 is a different thing altogether.
Yes. No,
Well,
my lord, the executing the relief which is sought from your lordship
Yes.
to record satisfaction because it is against a party.
No, let's forget this about this court.
Yes, about this court. Yes, my lord, if it goes to
Even there,
Jaipur.
they'll file the same application.
Yes, they
For court satisfaction
Yes,
regarding
they
the
would be
award.
entitled to it if there is no stay in the 34. If I,
Exactly.
I bow down, of course.
If
Your
there's a
lordship has
stay in the
hit the
34,
nail on the head, my lord. Your lordship knows why I'm opposing.
my lord, my learned friends find my
I
lord
don't
Jaipur
want
to
to
be a
say.
more comfortable venue for them. Well, I find my lord, ultimately, my lord, this matter had reached the Supreme Court with regard to where should be the arbitration be, what is the seat of arbitration.
Right.
Ultimately, the Supreme Court, my lord, after a long round of litigations, directed it should be held in Calcutta. Those judgments I shall show you, lordship, my lord, because my learned friend now, my lord, contends that, my lord, the natural seat,
Yes.
my lord, is Jaipur.
Right.
So, my lord, I have to just, my lord, disabuse your lordship's mind on that notion. My lord, what the Supreme Court has said, what is the natural seat, why it came to Calcutta after, my lord, several years and several rounds of litigation.
Important, to decide this.
That's right.
The background is important, Mr. Sir.
I'll put that on affidavit.
Grateful.
Grateful.
The technical matters to take up your lordship's time, and your lordship has more pressing business.
But it's interesting.
Yes, ma'am. It's a point of law. It's
On execution days, I like these kind of matters.
grateful, brother. Bye.
Manata, in item number 5, I am paying not today. And the problem,
Right.
one application has been filed, and that has been in the master court. The order number has yet not been received. For that reason, I am unable to serve the copy of
Not today.
grateful.
Because I am appearing in item number 6 on behalf of the petitioner. Because I have checked there is a technical default in this for the jurisdiction. I wish to withdraw it and with the liberty to file it before the appropriate court.
Learned counsel for the petitioner seeks to withdraw the present petition with liberty to file appropriate proceedings in accordance with law. The matter
May I also request one more thing, Mulaz. The original award has been filed with the registry, Mulaz. That may be returned if Mulaz, so that I can file it in the commercial court.
we are gonna dismiss the liberty as prayed for is granted. The petitioner states that he has wrongly filed the present execution petition before this court. He seeks to withdraw the original award filed with the execution petition. Full stop. Let the department, this court permits the award holder to withdraw the original award deposited filed with the present execution petition after replacing the same with a certified copy. Full stop. If the same is done, the registry is directed to hand over the original copy of the award to the award holder with the aforesaid direction.
I'm grateful.
Present petition is dismissed as withdrawn.
I'm grateful, Your Lordship.
Item number 7, Lordship, I'm praying for Northeast Week. Advocate and record my lord not well, Your Lordship.
Not this week.
Your Lordship, this is my execution application, Your Lordship, arising from an award dated 31st of January 2026, Your Lordship. The service is complete, Your Lordship. May I file the affidavit of service? The award is arising out of a franchisee agreement, Your Lordship. The operative portion.
Take down. The award holder has preferred the present execution petition.
Lordship, I would be praying for a direction of affidavit of asset, Your Lordship, on this side. Since service is complete, Your Lordship.
Seeking execution of the award dated 31st January 2026. That's the date of the award, right?
Your
The
Lordship.
date of the award is
31st January 2026, Your Lordship.
Passed by the arbitral tribunal. The award debtor is directed to file his उससे पहले डाल देना affidavit of service taken on record. The award debtor is directed to file the affidavit of assets within a period of 3 weeks. Let's this matter after 4 weeks. उसमें एक और लाइन डालना affidavit of service. The order shall be communicated to the award debtor. Affidavit of service to be filed on the next day.
Lordship, I am appearing for the award holder in this matter. Lordship, by an order dated 9th July, Lordship had confirmed the sale.
Yes.
Lordship had confirmed the sale in favor of one Mr. Boidonath Chakraborty of the asset. Lordship, there were 3 weeks given for the confirmation of the sale, but Lordship, he couldn't arrange the amount and he backed out. He did not pay for the same. Lordship, today we have a higher bid of rupees 12,10,000. Lordship, we have also informed the receiver about the same. Lordship, I was praying if the same could be confirmed in the name of the new bidder. Lordship, this is the details of the bidder. This is the letter given to the receiver regarding the same. And this is the details of the new bidder.
Learned counsel for the award holder submits that the earlier bidder, namely Vedanath Chakravarti, had expressed his unwillingness to proceed with the purchase of the, it's a vehicle, right?
Yes, yes, Lordship.
Of the said vehicle. Full stop. The petitioner company has identified a new prospective bidder, Mr. Muhammad Imtiaz, residing at 7 Qazi Safiullah Alam Lane, Aura, who has submitted a bid for a sum of rupees 12 lakhs 10,000 for the said asset. The said development shall be communicated to the learned receiver.
Lordship, it's already communicated through this letter.
The learned receiver shall carry out the sale.
Lordship.
It shall proceed with the sale proceeding in favor of the new bidder, Mr. Muhammad Imtiaz, and file a report on the next
Lordship.
list after.
Lordship, after 3 weeks.
But in this matter, I am appearing for the petitioner, my lord, led by Mr. Rudraman Bhattacharya. He is not well, my lord. I am praying for not today, my lord.
Very interesting question, as your lordship was pointing out. My lord, award passed. My lord, award is under challenge, but my lord, that challenge stands separately. There is no stay. Now, my lord, here, my lord, the award has been put in execution after, my lord, more than 12 years. We take the point of limitation, we say that it's inexecutable. My learned friends take, my lord, the very interesting point that, my lord, under the previous act prior to its amendment, and not under previous act, under the act prior to its amendment, well, there was a natural and automatic stay of execution of all awards once a section 34 is filed. Whether that would save the limitation. Because, my lord, it is only after the 2015 amendment that the position, my lord, got rectified. Correct. Now, my lord, here the Supreme Court has ultimately, my lord, said that this amendment is only clarificatory. And since it is only clarificatory, there was nothing which could have prevented you from seeking execution of the award at the time, my lord, or when you ought to have filed for execution. That is within the first period of 12 years. And that view has been recently, my lord, affirmed by a division bench of our High Court. I must, my lord, confess that there are one or two contrary judgments of our court, other courts. But, my lord, this judgment of the Supreme Court is, my lord, a 3-bench judge. Oh. So, my lord, it's something that will hold the field.
Interesting. Where is it?
Next week, my lord.
Not today.
Grateful, my lord.
Lordship, in 11 is praying for a short pass over. Mr. Rahul Arya is appearing. He will appear virtually, Your Lordship. 11.
Oh, sorry.
Lordship, just he's on his legs, Your Lordship, in Supreme Court. Just a short pass over, Lordship. He will join.
Transfer a password.
Your Lordship, Kali not today, then, Lordship.
Have it next.
Not 12.
I think these are connected. 11, 12.
30.
But my application for execution, my learned friends taken out an application under section 47.
Well, I had on the last occasion showed your lordship.
So for, and then only
Very
my
narrow
I don't
compass in electricity.
yes.
Yes, my lord. Your lordship's judgment is also there now.
Yes.
Well, following electricity, LNT.
We have
But
forwarded him
I
the
have also given only the narrow interpretation.
Yes, yes. And my lord, I am only on the narrow interpretation. Your lordship, my lord, I am conscious that your lordship cannot travel. But my lord, only one judgment I think I need to show your lordship.
Well,
it was
you didn't give it to me.
It is your judgment.
Oh, I'm going to show.
I'm going to show.
Oh. I have given him my 2 judgments. Your lordship's judgment is only on the preliminary point that my learned friend is addressing today.
My lord,
it's a narrow compass, can't go behind the decree. Now, what my learned friend is saying is that the consortium which is the claimant. They, two of them have gone into liquidation. It doesn't exist anymore.
Well, it's not that, I shall show you, Lordship. I have to, first get over the threshold question. Now, your Lordship has seen electro-steel. Your Lordship has noticed that it's only in the case of a nullity. Now, what would answer the question of nullity? I, of course, have to address your Lordship. But first, your Lordship will have to, be satisfied. Because what my learned friend attempted to first contend was that...
The moment we use the word nullity, the scope becomes very narrow.
Yes.
Either fraud or today a unilateral appointment, something like, which hits at the root of the award.
That's right, and that is what happened. And here we say it's a root question. I'll show you, Lordship, the judgments why I say it's a root question. I'll support it with arguments on that. It becomes a root question for the simple reason that, here, the arbitral tribunal could not have accepted the reference. That becomes a root question. It could not have accepted the reference because today, the consortium...
That's not the merit of the issue.
No,
The moment you are saying that whether the arbitral tribunal could have accepted it or not, then it is the issue of arbitrability, and it can't be a fraud in terms of an.
No, it's not a fraud.
So even in terms of, it can't be a nullity, because the moment you're saying that they didn't have the jurisdiction or they didn't have the power to entertain it, these are all issues which are on the merit.
If these are disputed questions of facts, most certainly. If the facts are admitted, if there's no dispute with regard to the facts, then the question is whether the arbitral tribunal could have entertained it at all. That with the greatest respect, I think is clear. And not only that, your Lordship just mentioned the question of fraud. Here the Supreme Court, after the electro-steel judgment, went on a detailed inquiry into the question of fraud, because it was of the question that fraud is also a matter which goes to the root of the matter, because fraud unravels all.
No, but in that case, the Supreme Court said that fraud can also be looked into by the arbitrator.
Yes, it is thinking of MMTC.
Yes.
Yes, MMTC, Justice Vishwanathan's judgment, there, he follows electro-steel. He accepts the very narrow compass. But then he also says that so far as fraud is concerned, fraud is something that goes to the root of the matter, so I'll look into it.
Correct.
And then he looks into it and finds that there's no fraud. But ultimately, when your Lordship says it is a narrow compass, the question is whether it is a narrow compass or not. Now, if it is not a narrow compass, not a question of nullity, of course, I'll have to seek my recourse in the 34 Code. But if it is a question of nullity, and I shall show you Lordship judgment on what would answer the question of nullity. Then it would not be a question which would have to await adjudication in a 34 proceeding. Now, all that I'm saying here is, here the admitted fact is that the tender was awarded to a consortium. Admitted fact, and this is without controversy, is that one of the members of the consortium had gone into liquidation much before the arbitration was commenced. The admitted fact is, on the records, and there is no controversy about this also from the award itself, that all the members, all the surviving members of the consortium also did not authorize the lead member of the consortium to come and file this application. And that is a violation of law. That goes to the root of the matter. 19(1) of the Partnership Act. That is the question. So, if your Lordship accepts the fact that your Lordship can go into that inquiry, then of course I can take your Lordship to the inquiry. Ultimately, your Lordship may hold that, yes, I will entertain the 47, but I don't find merits in it. That is a different matter altogether. But here, so far as the threshold question is concerned, the question which my learned friend had first raised, which I think is now no longer res integra, is that if your remedy lies in a 34 situation, if you have suffered an award and your remedy is by way of 34, then you have to go to 34, you cannot come to section 47. That question is now answered by your Lordship. Now, it is no longer in controversy that even if I have a remedy in 34, even if I have filed a 34 or I have not filed a 34, I can still come under section 47 if I can show, because I'm not asking your Lordship to go behind the award. If I can show to your Lordships that so far as this question is concerned, this is a question which renders the award null. Now, your Lordship has in L&T, really answer the question that unilateral appointment. That is against the law. Because it now violates the 7th schedule of the Arbitration Act, etc., etc. Similarly, if there's a violation of law, which would render the tribunal incapable of receiving a reference, then my lord, the question is whether it would be a nullity. Well, I'll address your lordship on the merits of the matter, but my lord, the question which my learned friend had posed, now my lord, of course, he wants to, my lord, address your lordship on whether this will amount to a nullity or not. I am prepared to answer that question. But my lord, his question before your lordship, for which my lord, your lordship was, my lord, previously concerned, was whether after having gone to 34, file an application on 34, you can still maintain a section 47 application in an execution proceeding. But if that question, my lord, is answered, then my lord, I can take your lordship to the rest of the matter.
And of course, if it's a nullity, a section 47 lies, and that has to be heard. My case is that my learned friend, the case he has come with cannot be a nullity, because that was the issue that was decided by the award. In the award, that issue is decided. I'm reading out one paragraph from the award.
That I will read out.
Mr. Shah, appearing for the respondent, gives a full reply on the merit. Ultimately took a question of maintainability of the claim on the ground that the application has not been verified lawfully by the claimant. This is the point he's taking now. Now, your lordship cannot go into the correctness. Three things from that falls from my lord's judgment. One is that it's a narrow compass. Then it has to be a nullity in law. There, in the case of electrosteel, it was a moratorium. Law prohibited that proceeding to continue. In the judgment of your lordship, there it was unilateral appointment. Ab initio, it was bad. Then, my lord, three things was, one was, one second, yeah. Yes.
If my learned friend wants to argue my petition for me, then he's welcome.
My learned friend finished. I took time. I was not there. Your lordship asked me to give the cases. I've given him my cases.
Now, my lord, I have
now only thing I want to just point out what, since my learned friend said the narrow compass is it a nullity or not? In this case, it cannot come under nullity. That was my case. And lordship cannot go behind the decree. My learned friend, in all fairness, should point out that he took this point in the arbitration proceedings. Section 16 was filed. In the award, it was argued. Extra notes for arguments were given. Every time it was there. He's taken it in 34. He's taken it in 36.
I shall show
but
you
he hasn't secured the claim.
With the greatest of respect, my
yes,
lord,
Mr. Shah, he will speak. I'm just asking
any hard words or harsh words.
Very harsh words have been used. This stuff, and my learned friend's client has made a counter claim for 600 crores. Dismissed. He's got nothing. That is not being said. It's not maintainable from the beginning. He has appointed one of the arbitrators.
So
he has appointed.
Proceedings are completed in the GA, right?
Yes, my lord. Your lordship
we can decide today.
Yes.
Yes, your lordship. Hear it out. My learned friend started. Let him finish. I'll answer once and for all.
Let's finish it. This was if the GA can be decided, then we can move forward.
Yes.
I will start, my lord, with my lord, so far as this is concerned. I think, my lord, so far as no, statement of claim. Let's start with section 19. No.
No, Joseph, MMTC and Joseph.
Lord, may I do this, my lord? Lord, may I? Because well, I think, well, Lord, it is in my best interest, because now that your lordship has pointed out what is in your lordship's mind without question of nullity. My lord, I have my notes, but my lord, I will have to then, my lord, ramble on for a bit. I want to, my lord, make it very concise. I now have understood your lordship. If your lordship hears me tomorrow, I can come back tomorrow.
Then next week we'll have it. Next Thursday.
Next Thursday,
monthly list. No,
next Thursday is monthly.
Well, may I? Any day, my lord. My lord, may I keep these two on record since I've given them to my learned friend? This is one is the MMTC, which considers electrosteel, and one is, of course, my lord's judgment. He can't go behind the decree. That means if the decree has decided it, he can't go.
Of course not. That is constant. Well, next Thursday, your lordship can take it up, because
maintain its position.
I don't have all the judgments. That's why if the nullity judgment.
Heard,
Those I don't have with me.
heard. Noted senior counsel. The Saha. List for further hearing. Thursday.
Yes, it's
Super
formed.
retail journal so that we can finish.
Well, I'm sure Mr. Shah will give me the judgments one day before. I'll also come
Yes, yes, I'll give it to you.
as sent us.
I'll give it to you.
Grateful.
Now 14.
This is my application for execution. This is in respect of an award. The amount now outstanding is a sum of 1 crore and odd. I tell your lordship, the only point that has been raised over here is at the time of section 34 pursuant to section 36(3, they had put in the money before this honorable court. And after the section 34 challenge had failed, the judge had given us the liberty. Whatever money was lying, we have got that. Now the question is, the short point taken in the opposition is that because they had put in the money, they are not liable to pay any further. That's the only point of law. Now that's well settled under Order 21, Rule 1. It's the arbitrator has given a certain rate of interest. The calculation has been given in paragraph 12, and I don't think the quantum is in dispute. This 1 crore and 9, this is the least they are supposed to pay, because this is in respect of an insurance policy where under the IRDA guidelines, if you delay, you are to pay interest 2% above the bank rate. The bank rate we had seen 6.5 and 2% above was 8.5. And there is no dispute with regard to that in their affidavit in opposition. And we have stuck to the rate as on the date of the award. It had increased subsequently.
Mr. Chaudhary, the GA.
My lord.
What is the GA?
Well, this is my lord IAGA 1. Na? 1, I think 1, IAGA 1. Well, kindly comes to my lord, I'll show your lordship 3 paragraphs.
But then the GA is exactly what the EC is. Why have you filed this GA?
Subsequent. Well, this is, my lord, EC was filed, my lord, the execution was filed, my lord, because section 34 they filed without filing a 36. So execution was filed. GA was filed subsequent to the dismissal of the section 34. Because, my lord, we have put in the subsequent fact, my lord, kindly comes to page 5.
Page 5 of the EC?
Of the GA, my lord.
Yes. Yes.
Well, at paragraph 7, lordship will find, my lord, order dated 7th April 2021 by Honorable Justice Moushumi Bhattacharya, award dated 2nd March was stayed conditionally upon the award debtor putting in a sum of 7 crore 16 lakh with the registrar original side, who was directed to invest the amount in fixed deposit. Then, my lord, paragraph 8, we have stated they intimate us, they have done so. Then, my lord, kindly straight away come to paragraph 9. The application for setting aside of the award being APCOM 186 was finally heard by Honorable Justice Aniruddha Rai, and by a judgment and order of 20th May, the same was dismissed. Learned registrar original side was directed to take steps forthwith to encash the fixed deposit and pay the entire amount with accrued interest upon compliance of all formalities. Then, my lord, this was intimated. Then, my lord, kindly comes to page 7. But at paragraph 10, we say,
so you have received 8 crore.
8 crore 76. Now, my lord, para 11, kindly see, my lord, awarded amount was, my lord, principal sum was 7 crore 16. And, my lord, the award provided interest at 8.75%, which is 2% above the bank rate. Bank rate was then, my lord, 6.75, 8.75. So, my lord, if the calculation is done for 4.5 years, my lord, the interest component comes to 2 crore 69 lakh. Total is 9 crore 85. So and then, my lord, page 8, paragraph 12.
Today you are looking at 2 crore 69.
My lord, I am looking at, my lord, 1 crore 9 only. My lord, kindly see, my lord, 9 crore. I have received 8 crore 76. 8 crore 76 lakhs. I am looking at 1 crore 9. This is as on the date of execution. The calculation, there is no dispute. The only point taken in the opposition is since money was secured in court, the clock stops. Well, that with respect is not the law. If my learned friend wants to pursue that, I have the judgments. Well, it's now well settled. Supreme Court, even this High Court, Delhi High Court, all are unanimous.
Yes, sir.
Kindly come to page 14 and 15 of this application.
Yes.
Page 14, Malot. May I read out?
Yeah.
This is an application under section. Kindly come to last line. Award which comes to the total total of rupees 3 crores 67 lakhs, which together with interest awarded would come to an amount of rupees 7 crores 16 lakhs. Upon hearing Landed Council appearing for the parties, the court is satisfied the petitioner awarded the primary case. The difference to the amount awarded is of according to the satisfaction of to the amount paid to the claimant in the arbitration proceeding. However, the parties are now added on the sum of rupees 7 crores 16 lakhs, which is also the amount which has been claimed by the award holder in the execution proceedings. Whatever the amount claimed in the execution proceedings, we have deposited the entire thing. The deposit, you will find at page 2021. Page 20. Page 20, your worship, and the fresh page 28. But on in compliance with that order, we have deposited the said sum before this honorable court. 7 crores 16 lakhs. The next page 21 is the check. We have already secured that amount, and it was as it was directed by the Honorable Justice Moshmi Bhattacharya. It was invested by the landed register original site. And you will find that page 60, 61, page 60, you will find that the landed they have withdrawn that amount of rupees 8 crore 88 lakhs 500.
But your tabular form also, when you filed your execution petition, you had sought 7 crore 16 lakhs.
Yes. Now, my lord, the short question was 7 crore 16 lakhs, my lord. Had they given it to us, the clock would have stopped. The whole question is, my lord, today it's like this. My lord, the question of law that arises is that today if an execution is stayed because of a conditional section 36 order, my lord, whether the clock with regard to interest stops or not.
That's what I'm asking. So the interest which is awarded at the time when it is kept with the registrar probably is on the lower side, right?
It's on the lower
That is
side.
the reason why
That's the reason why this difference. That is why, my lord, now, my lord, lordships permit, my lord, withdrawal of the deposited amount upon furnishing a bank guarantee, because commercially it makes sense, my lord, that the decree holder or the award holder gets the money. Lordship permits.
In fact, that provision was also there. They have not.
I just wanted to understand how did this balance?
Yes. It is because
the awarded amount was 8.75.
8.75,
Interest rate would have been
6% or 6.5% in State Bank of India. That's why the difference is there.
In fact, yes, whatever the amount, that 7 crore 16, whatever the amount deposited before this honorable court, we have intimated that look in compliance with that order, we have deposited. After that, no withdrawal application has been filed. They have not taken any steps, but it was invested, and after the disposal of the section 34, they have withdrawn. My question is very limited. That on the date of deposit, that entire principal amount together interest, whatever they have claimed in the execution proceeding, when I deposited that amount, the running of interest will stop run. That is my.
That's your argument.
That is my argument. On that condition, I'm placing the judgment first.
Yes.
To make the first judgment that is reported in 2006. That is 2006 8 Supreme Court cases 457. It's the 5 judges bench.
Yes.
May I just place the relevant paragraph is paragraph 28. Paragraph 28.
Yes.
May I read out,
Yes.
Got it, Malak?
Yes.
Going by this principle and for a moment keeping out the scheme of Land Acquisition Act, it appears to us that on payment or deposit of amount awarded by the collector in terms of Section 11, dated Section 31 of the Act, the claimant cannot thereafter claim any interest on the part of the compensation paid to him or deposited, for the payment to him once notice of deposit is given to him. Whatever the amount deposited before this honorable court, we have given notice to them that look, in compliance with that order, we have deposited such and such amount before this honorable court. Thereafter, when the reference court enhances the compensation with consequential enhancement in solatium and interest under Section 23(1)(a) of the Act, and further awards interest on the enhanced compensation in terms of Section 28 of the Act, the claimant decree holder can seek an appropriation of the amounts deposited pursuant to the award decree only towards the enhanced amount so awarded by the reference court, only to the enhanced amount. And there is no, in this case, there is no enhancement. While making the appropriation, he can apply the amount deposited first towards the satisfaction of
The
his claims.
facts are slightly different over here.
Malad?
The award.
Yes.
Everything is claimed under the award.
Yes.
If the award has granted an interest
Yes.
of whatever 8.75,
Yes. Yes.
that should have been satisfied in terms of the award.
Yes.
Right? So the facts of this case, whether they are applicable in your matter, is something which we have to see because this is land acquisition. Land acquisition, there is a certain amount of compensation which is paid. Somebody files for an enhancement. From the time of the enhancement, maybe the interest which has accrued is being paid to you. But as far as the compensation is concerned, you are reading out that that stops. There can't be any interest on it.
Yes.
Correct?
Yes.
Whether that can be applied in terms of the award is something which we have to see. So do you have any judgment as far as this proposition is concerned?
That is the main proposition led.
As far as the Arbitration Act is concerned, as far as
Yes, I'm coming because this is the judgment. 5 judges bench. Subsequently, it was followed by all the other judgments.
But this can be distinguished on facts.
Maybe difference of fact, maybe difference of, but the ratio. Ratio of interest.
Even of the ratio of interest.
Yes.
See, here is a award.
Yes.
Which needs to be executed.
Yes.
Whatever the findings are given by the arbitral tribunal to the extent X amount plus interest
Yes.
at the rate of
Yes.
8.5 or 9 or 12, whatever percentage.
Whatever percentage.
So he is claiming that balance
Balance.
at the time which you have deposited and the award to the satisfaction of the award.
Yes.
So that is what it is.
That is, Malad, here, Malad.
Here it's different.
No, may I just clarify, Malad? Malad, 7 crore 16 lakhs. That amount, inclusive of interest, whatever Malad interest granted in the award, we have deposited it before that. They can Malad file Malad application for withdrawal, securing Malad bank security. They Malad did not. It did not. They waited for some. In fact, it was the amount was invested, and they took the interest also. Here, interest, with the Supreme Court, this Gurpreet Singh judgment says when the principal amount together with interest is being deposited before the court or paid, then running of interest will stop run. That is the principle of interest. Whatever whether that is the Land Acquisition Act, whether it's a Motor Vehicles Act, whether it's a Arbitration Act, that is not only towards enhanced amount so awarded by the reference court. While making the appropriation, he can apply the amount deposited first towards the satisfaction of his claim towards interest on the enhanced amount, the cost, if any, awarded and balance towards the land value, solatium, and the payment under Section 23(1)(a) of the Act, 23 of the Act, and if there is a shortfall, claim that part of the compensation with interest thereon as provided in Section 28 of the Act and as covered by the award decree. Once the sum enhanced by the reference court along with the interest is deposited by the state, there will be no occasion for the claimant awardee to seek a reopening of the amount awarded by the collector, substituted by the amount awarded by the reference court, and to seek have an appropriation the amount towards what is due. Same would be the position in a case where the amount awarded by the reference code, including the interest, is deposited, but the amount is further enhanced in appeal by the High Court. Again, the same principle would apply. The principle would continue to apply when the Supreme Court award further enhancement in a further appeal to that court. But if after the award by the reference court, the amount is not deposited by the state, interest would run on the compensation in terms of Section 28 of the Act on that amount as provided in Section 20. The same would be in the position regarding the enhancement given in appeal by the High Court and in the enhancement given in appeal by the Supreme Court. The mandate of Section 34 and Section 28 that interest would run from the date the collector takes possession till the particular amount is deposited as provided in those sections ensures that the claimant is recompensated adequately. Section 28 ensures such recompensation at each stage of enhancement of compensation. Here, whether it is a land acquisition act, whether it's an arbitration act, whether it's a motor vehicle act, or whatever it is, here the question is the principal ratio decided on the issue of interest. What is interest? When the judgment data deposited, the entire awarded sum together interest, and they have a full knowledge, then running of interest will stop run, because you have an option to withdraw that amount after securing the guarantee, bank guarantee or any other guarantee. But you did not take that steps. Second, my lord. Considering the same ratio, my lord, and submitting to my lord, that is my lord, 2013 one Supreme Court cases 243. The division bench judgment of Honorable Apex Court. I'm page paragraph 31. Yeah. Paragraph 31. Got it, my page 259. From what has been stated in the said decision, the following principles emerges. Said decision means kindly come to the just previous page. Just come to the previous page, yes. That same images, that is Group 6 judgment. That earlier that I filed that 5 judges bench, Constitution bench judgment. Here, Bail also that follows the same ratio. 31.1. The general rule of appropriation towards the decretal amount was that such an amount was to be adjusted strictly in accordance with the directions contained in the decree, and in the absence of such directions, adjustments be made firstly towards payment of interest and costs, and thereafter towards payment of the principal amount, subject, of course, to any agreement between the parties. Next, the legislative intent in enacting sub-rule 4 and 5 is clear pointed that interest should cease to run on the deposit made by the judgment debtor and notice given or on the amount being tendered outside the court in the manner provided in Order 21, Rule 1 on 1B. Here the issue is only the interest. Whether it was under any act, that is not the issue. Here, what would be the interest? Whether the interest will run after depositing the amount, or it was ceases to be stopped. Yes, the same ratio. Yes. Next, if the payment made by the judgment debtor falls short of the decreed amount, the decree holder will be entitled to apply the general rule of appropriation by appropriating the amount deposited towards the interest, then towards costs, and finally towards the principal amount due under the decree. In cases where there is a shortfall or in deposit the principal amount, the decree holder would be entitled to adjust interest and cost first and balance towards the principal, and beyond that, the decree holder cannot seek to reopen the entire transaction and proceed to recalculate the interest on the whole of the principal amount and seeks for reopening. Here also not clear. If falls short, then on that amount, the interest will run. If the claim amount is awarded amount is 10 rupees, we have deposited 8 rupees. On 8 rupees, there will be no further interest. But of course, on 2 rupees, there will be interest from date of whatever the what in the given, whatever that the shortfall will run interest. But deposited sum, there will be no interest. Keeping the view of principle in mind, when we examine the case on hand, we find from the judgment of the learned single judge, which has been affirmed by the division bench, that the principal amount due along with the interest thereon on the date of the first payment, namely 18 October 1985, as well as based on subsequent payments on the remaining principal amount and the interest due thereon, which has been set out in the last part of the judgment at the certain judge of the learned single judge, the following summary. Therefore, the merits of that case, here the year also, considering that Group P6 judgment, the bail also considered, yes, running of interest will stop run on the date of deposit when they have a full knowledge. If they have don't have a knowledge that you have deposited that amount, in that case, the principle would be different. They have a full knowledge. We have communicated the same. Then agreed that they have full knowledge. Even that, they have not withdrawn any sum. They have not applied any sum. Next, my lord. Another 3 judges bench, considering the same ratio. That is 2014, 5 Supreme Court cases, 577.
Page.
Kindly have the paragraph straightway. Paragraph 22. Para 22, straightway. Lordship got it, Para 22. That group is Singh and also Bhel. What we have, I have already submitted before Lordship that in Gurpreet Singh, the Constitution bench of this court had an occasion to consider the issue regarding execution of money decree, the principle of appropriation and its applicability, which was recently followed by this court in Bhel versus R.S. Avtar Singh and Company, and cooled down the principles laid down in Gurpreet Singh's case as follows. The general rule of that principle is attached here to it, that the general rule of appropriation towards the decretal amount was that such an amount was to be adjusted strictly in accordance with the directions contained in the decree, and in the absence of such directions, adjustment be made firstly towards payment of interest and the cost, and thereafter towards payment of principal amount, subject, of course, to any agreement between the parties. The legislative intent in enacting Sub-Rule 4 and 5 is a clear pointer that interest should cease to run on the deposit made by the judgment debtor and notice given or on the amount being tendered outside the court in the manner provided in Order 21 Rule 1 and B. That is the principle laid down in the Gurpreet Singh and Bhel. That principle is being followed. Then paragraph 23, in the judgment referred to by the High Court in the impugned judgment, this court and the Privy Council have consistently taken a view that in case of appropriation of amount, unless the decree contains a specific provision, the amounts have to be appropriated as contemplated under Order 21 Rule 1. If there is a shortfall in deposit, the amount has to be adjusted towards interest and cost. Then it has to be adjusted towards principal. The High Court has failed to appreciate this fact and misdirected itself in observing that these judgments are prior to the amendment to Order 21 Rule 1. In our considered view, as far as this aspect is considered, there is not much difference in the provisions prior to or subsequent to the amendment, because in the objects and reasons for the amendment to Order 21 Rule 1 CPC, as observed by the Constitution bench in Gurpreet Singh, the legislative intent in enacting Sub-Rule 4 and 5 is that interest should cease on the deposit being made and notice given or on the amount being tendered outside the court in the manner provided. The intent of the rule-making authority is to leave no room for any frivolous pleas of payment of money due under a money decree. Same principle. A three judges bench of honorable apex, same principle. my lord. When the deposit is being made with interest and they have a full knowledge of that, then running of interest will stop run. The judgment debtor is no need to pay any further interest on the amount my lord, awarded by the learned tribunal. Next, my lord, this is the unreported judgment, my lord.
I am not disputing it. Supreme Court থেকে
এটাও
আবার মাল্টিপ্লাই করছো
এটাও রিসেন্ট জাজমেন্ট
21 rule মানে
হ্যাঁ সবই সেম প্রিন্সিপাল সেম রেশিও on the issue decree under which act, that is not the important. Here the ratio is being decided on the issue of interest under the Interest Act. Section 4 and 5 of the Interest Act, what would be the interest? Same same issue is being decided. That is the unreported judgment recently, that is January 16, 2026, just recent judgment. The same ratio is being adopted by the honorable advisor. Just paragraph 23 onwards, para 23 onwards, same ratio is being observed, and the Supreme Court is finding of the Supreme Court is very clear that the interest will stop run on the date of deposit. That is my humble submission. Paragraph 23. Paragraph 23. 23 onwards.
So when the money was deposited, the principal, it was with the interest of 8.75. What was the interest? 8.75.
8.7. I am not
It
disputing.
was with the interest, the money was.
Factually, there is no dispute. It's a pure question of law.
Yes. Anything else?
No. That's my
Well, the only question of law is all the judgment cited by my learned friend is on the principle of Order 21, Rule 1, and I'll place that. The question is, there are, my lord, in Civil Procedure Code, two modes of depositing money. One is under Order 21, Rule 1, which is in the execution proceedings. The judgment debtor comes on its own volition, deposits the money, and gives a notice to the decree holder that I have deposited the money. This is one provision of deposit. Consequences are different. My lord, all these, the 5-judge bench and my lord, what has been followed, my lord, it's the apt law. But here, my lord, it's not a deposit under Order 21. It's a deposit under the provisions of Order 41, Rule 5. My lord, because, my lord, this deposit is being done not on its own volition, but because of an order of court seeking a conditional stay. Because the lordship knows, section 36, subsection 3, the proviso says that, my lord, the principles of, my lord, Order 41 would apply. My lord, lordship has a look at, my lord, 36.3 first of the Arbitration Act. Upon filing an application under subsection 2 for stay of operation of the arbitral award, The court may, subject to such condition as it may deem fit, grant stay of operation of such award for reasons to be recorded in writing, provided that the court shall, while considering the application for grant of stay in case of an arbitral award for payment of money, have due regard to the provisions for grant of stay of a money decree under the provisions of Code of Civil Procedure. Now, my lord, the provision of Code of Civil Procedure in this regard is Order 41, Rule 5, stay of decree. Kindly have a look at Order 41, Rule 5. একটু civil procedure কোডটা দিন। পেয়ে গেছে। An appeal shall not operate as a stay of proceedings under a decree or order appealed therefrom from except so far as the appellate court may order, nor shall execution of a decree be stayed by reason of only of an appeal having been preferred from the decree. But the appellate court may for sufficient cause order stay of execution of such decree. Now, my lord, in this sufficient cause, my lord, all these conditionalities come. Now, my lord, to cut short the issue, the question of law is whether in such circumstances a stay granted conditionally by the appellate court or on similar principles where the defendant or the judgment debtor is securing a stay of that will be at par with the principles of Order 21, Rule 1. Now, my lord, this issue has been settled by the Supreme Court and my lord, it's still holding field as early as in 1968. My lord, the judgment, my lord, three-judge bench of the judgment authored by Justice G.K. Mitter. Kindly have a look at. Now, this is AIR 1968 Supreme Court 1047. Will it kindly see just the factual background in paragraph 2, two sentences. Facts necessary for the disposal are as follows. Respondent's father made a deposit of 5,000 with the appellant's father in so-and-so. Demand was made in 1944. A suit for recovery was made. Trial court decreed the suit in the year 1946 for 11,459. The appellant's father preferred an appeal therefrom to the High Court and pending disposal of the same deposited 3,500 in court on 16th April 1947. High Court confirmed the decree on 14 September 1951. There is some dispute about the actual date, but there is no contest.
If we assume, then what is the whole purpose of staying the award if your interest still goes on?
Yes, but there are two things.
If the interest continues, what is the purpose?
Because my lord, the difference in Order 21 and Order 41, Rule 5, my lord, this is what the ratio is, my lord. Kindly have a look at this. And my lord, it has been held, this is the position in law consistently followed even in Delhi High Court and even in Calcutta High Court. I'll cite all the judgments. What, my lord, the entire catena of cases which...
Come back in 5 minutes. Give me 5 minutes.
Yes, yes.
Yes.
My lord, I was placing the judgment of 1968 3 Supreme Court reports 367. But the relevant paragraphs are paragraphs 12, 13 and 15. Kindly straight away come to paragraph 12. I first showed your lordship paragraph 2, 12, 13 and 15. Because, my lord, this is the parent Supreme Court judgment which has been subsequently followed by the division bench of the Delhi High Court. Identical contentions raised.
So, Chaudhary, if we accept your argument,
Yes.
in that case, any stay which is granted by the court is a nullity.
No. Well, at the stay order, well, it's well settled now. I hope, I think I'll be able to show your lordship, well, convince your lordship. Well, exact argument based on the constitutional judgment, identical argument, well, negated by the division bench of Delhi High Court following this, and well, our court has also proceeded. I'll come to that step by step. Well, kindly come to paragraph 12.
Yes.
On principle, it appears to us that the facts of a judgment debtors depositing a sum in court to purchase peace by way of stay of execution of decree on the terms that decree holder can draw it out on furnishing security does not pass title to the money to the decree holder. He can, if he likes, take the money out of term of the order, but so long as he does not do it, there is nothing to prevent the judgment debtor from taking it out by furnishing other security, say of immovable property, if the courts allow him to do so, and on his losing the appeal, putting the decretal amount in terms of Order 21, Rule 1, in satisfaction of the decree. The real effect, this is very important. The real effect of deposit of money in court, as was done in this case, is to put the money beyond the reach of the parties pending disposal of the appeal. The decree holder could only take it out on furnishing security, which means that the payment was not in satisfaction of the decree, and the security could be proceeded against the judgment debtor in case of his success in the appeal. Pending the determination of the same, it was beyond the reach of judgment debtor. Then, my lord, Chautmal's case has been distinguished. Kindly come to paragraph 15. The last contention raised on behalf of the respondent was that at any rate, the decree holder cannot claim any amount by way of interest after deposit of money in court. There is no substance in this point because the deposit in this case was not unconditional, and the decree holder was not free to withdraw it whenever he liked, even before the disposal of the appeal. In case he wanted to do so, he had to give security in terms of the order. The deposit was not in terms of Order 21, Rule 1 CPC, and as such, there is no question of stoppage of interest after the deposit. So, my lord, this is how, my lord, the Supreme Court distinguishes what is the effect of a deposit in terms of Order 41 and, my lord, contradistinct it with Order 21. Now, my lord, the identical question, what has been argued by my learned friend, comes up before the division bench of the Delhi High Court. My lord, kindly takes 2009 SCC Online, Delhi 519. Lord, Lordship can make a note of the relevant paragraphs. Is paragraphs, my lord, 15 to 20 and 21, 15 to 20 and 22 and 23. But I will read only 3 paragraphs out of this. And in this, well, the constitutional bench judgment was relied upon, which my learned friend has done. Gurpreet, the case of Gurpreet has been relied upon. Well, kindly straight away come to paragraph 17. Paragraph 15 onwards, my lord, it analyzes the provision of Order 21, Rule 1. Kindly straight away come to paragraph 17. In our view, the act of making payment to the decree holder under Rule 1 of Order 21 CPC would require a positive act on the part of the judgment debtor of either depositing into the court whose duty is to execute the decree or payment out of court to the decree holder, though through a postal money or through a bank or through any other mode where payment is evidenced in writing, unless the court which made the decree otherwise directs. The payment made under a decree to fall within the ambit of Order 21, Rule 1 CPC has therefore necessarily to be an unconditional payment.
You could not lay your hands on any of the judgments where, the issue is directly addressed.
But this is directly addressing. Well, this is Order 21, Rule 1, and contradicting to Order 41, Rule 5. And this has distinguished the Constitutional Bench judgment in Gurpreet. I'll show you, Your Lordship, kindly see. Judgment to the decree holder directly or indirectly through the medium of court whose duty is to execute. Next line is very important. Mere deposit of the decretal amount in a court other than an executing court can never amount to payment, and even where the decretal amount is deposited in the executing court, the judgment debtor's liability to pay interest does not cease until notice contemplated under sub-rule 2 of Rule 1 of Order 21 is given. This is evident from sub-rule 4 above. Order 21, Rule 1 does not contemplate the decree holder having to chase the judgment debtor to realize the decretal amount by seeking attachment of one or other accounts of the judgment debtor or the properties of the judgment debtor. Well, kindly straight away come to para 19. Exactly identical argument was made. The submission of the appellant, judgment debtor, that mere deposit of the amount in FAO so-and-so resulted in the stoppage of accrual of further interest from the date of deposit is also meritless. Even in cases where the decretal amount flows into the coffers of the decree holder, subject to the decree holder being required to furnish a security during pendency of an appeal, the Supreme Court has held in PSL Ramanath Chettiar that such payment does not tantamount to payment of money under the decree. Then, my lord, paragraphs 12 and 13, which I have shown your lordship, has been quoted. Kindly straight away come to para 20. The situation in the present case is still worse for the appellant, inasmuch as the amount deposited in FA so-and-so was not released to the respondent till after the passing of the order dated 27th April 2006. Amount lying in deposit in the disposed of FAO was not a deposit made in executing court in terms of Order 21, Rule 1. Admittedly, the said deposit could not be construed as direct payment. Then, my lord, kindly comes to para 22. Well, the same series of judgments following Gurpreet Singh was referred to, and my lord, the division bench, my lord, distinguishes that. In our view, the decision of the Constitution Bench of the Supreme Court in Gurpreet Singh Supra is of no avail to the appellants in the facts of the case. In this case, Supreme Court was considering the aspect of the right of the decree holder to claim interest and to appropriate the amount deposited by the judgment debtor in pursuance of a court decree in different situation. The Supreme Court, while stating the legal position in para 20 and 21 quoted above, was dealing with a situation where the judgment debtor makes a deposit in executing court. This is clear from a plain reading of the above extract. However, in the present case, it cannot be said that the appellant had made deposit in executing court, since the deposit had been made in FAO so-and-so. Therefore, we are of the view that the mere fact that the deposit of 58,80,000 was made by the appellant as a condition for grant of stay of execution of the decree dated 2nd August, which was eventually set aside on 20th April 2004, does not entitle the appellant to claim that interest in terms of the decree had stopped running from the date of deposit. No doubt, the interest earned on the deposit made in FAO would inure to the benefit of the appellant. We are also of the view that the appellant did not avail of the conditional remission of interest granted in the decree so-and-so by making payment. Well, that's a quantum of rate. My lord, exact identical argument, my lord, based on Gurpreet's ratio, my lord, was made. And this is, my lord, I adopt this distinction. My respectful submission would be that the entire series of law, which my learned friend relied, following the Gurpreet Constitutional Bench ratio, are all on Order 21, Rule 1, my lord, which cannot have any application, my lord, so far as a conditional stay is made upon deposit, for two reasons. Number one, my lord, the money is deposited, it is out of the hand of the decree holder. If the decree holder is to retrieve that money, it is not that the decree holder is getting the benefit of the money. And my lord, number two, my lord, it is not a notice under Order 21, Rule 1, because, my lord, it's in executing court, where, my lord, it's not that the decree holder has to chase any further. Moment a notice is given, my lord, if I take 6 months to come and collect it, interest will stop. But that is not the same as that, my lord, under Order 41, Rule 5. And my lord, now, my lord, our coordinate bench judgment of our High Court, identical arguments were advanced. That I had deposited it pursuant to order for appellate court's order to grant a conditional stay. Here also, my lord, 36(3) is nothing but principles of Order 41. You are getting a conditional stay upon deposit. Well, the fundamental difference is, if a deposit is made under Order 41, Rule 5, well, the decree holder cannot, my lord, withdraw it unconditionally. He has to put in a bank guarantee or something. But, my lord, unlike Order 21, Rule 1, moment, my lord, the judgment debtor puts in the money, my lord, decree holder can take it away unconditionally. I can take it, my lord, on the very next day. I can come and take it after 6 months. If I delay in taking it away in 6 months, my lord, no further interest will accrue. So the principles are fundamentally different. Will it kindly marks, my lord, para 9, 10, and 16 of this judgment. Well, here what had happened, my lord, a sum of 1.5 crore was attached pursuant to order of court. And my lord, the judgment debtor came and contended that because this amount was attached, my lord, interest had ceased to run. Because I have been out of pocket with this money. My lord, following the principles of, my lord, Delhi Development Authority, my lord, this question was decided. My lord, kindly comes to para 10. Para 9, my lord, Order 21, Rule 1. I'm sorry, my lord, para 9, if I may just please. Learned advocate appearing on behalf of the decree holder has contended that money decree has to be satisfied only in accordance with the provisions of Order 21, Rule 1 of the Civil Procedure Code. It is further contended that attachment of the amount of 1.5 crore by the order of court on 16 June 2015 was not available to the decree holder, as the judgment debtor challenged the decree passed on 31st October, and for that reason the instant execution case remained out of list for a considerable period of time by the order of court dated 25th April 2016. Thereafter, due to disposal of the review application on 8 June 2022, the executing court on 1st July 2022 directed the State Bank of India to release attached amount of 1.5 crore in favor of the decree holder, and State Bank took time to exercise for releasing such amount in favor of the decree holder. Thereby, according to Mr. Chaudhary, decree holder received 1.5 crores towards principal amount on 16th August 2022, and the balance amount of 6,68,000 was paid to the decree holder on 26th August 2022. Then, my lord, Delhi Development Authority has been referred to. Will it kindly straight away come to page 14 of that order. Paragraph 11. In opposition to that, learned senior advocate appearing on behalf of the judgment debtor has argued that account of decree holder was attached by the order of court on 16 June 2015, and from then on, judgment debtor had no access to that amount in that account, and more so, the amount was available to the decree holder. Therefore, according to Mr. Singhania, interest in terms of decree towards 1.5 crore had stopped running. According to the decree holders are entitled to interest till 60 months. Identical argument that I have been out of pocket, my money has been attached, so no further interest would accrue. Now, my lord, kindly straight away come to paragraph 14. At the very outset, it would be profitable to lay out the provision of Order 21, Rule 1, prescribing modes of money under a decree. It reads as follows. Modes of paying money under decree: all money payable under a decree shall be paid as follows. Because in the Supreme Court decision, Lordship will find the expression when it is paid by deposit into court whose duty it is to execute the decree, or sent to that court by postal money order or through a bank, or out of court to the decree holder. So on your own volition, you are either paying it to the decree holder or you are coming and depositing it in court. Then, my lord, kindly straight away come to, my lord, the rest of the provision has been quoted. I am not troubling your lordship. Page 18, para 15. Therefore, a decree for money can be executed either by deposit into court or by paying the decree holder out of court under Order 21, Rule 1AB. So far as Order 21, Rule 1C of Civil Procedure provision is not applicable in the executing court simpliciter. Here in this case, admittedly, judgment debtor's account was attached by order of this court dated 16 June to secure the money. Mr. Singhania, on behalf of the judgment debtor, has tried to make this court understand that money so attached was available to the decree holder on and from 16 June 2015 when the account of the judgment debtor was attached. But factual provision is that one review application under Review 10 of 2015 was filed by the judgment debtor against the decree dated 31st October 2014. According to Mr. Singhania, the review application filed on the issue of interest only against the principal amount which was attached by the order of so and so, and therefore there was no impediment for withdrawal of the principal amount attached by the court. To explain the availability, it would be just to refer to 3 orders of this court, so and so. Conjoint reading of 3 orders, it is found that the execution matter went out of list, and on 5th July again the execution case came into track, and bank was directed to release the attached amount of 1.5 crores on so and so. Specifically, from the order dated 5th July, it appears execution case was kept pending on the ground of pendency of the review application. Therefore, no question of the amount attached being available for appropriation to the decree holder within the meaning of Order 21, Rule 1, Code of Civil Procedure Code. In the background, as aforesaid and circumstances, attachment would not tantamount to payment, even if we take assistance of Ranjit Singh Rana. I am sorry to subscribe to the view of Mr. Singhania that attachment of the account of judgment debtor tantamount to payment of decretal dues within the meaning of so and so, decree holder is entitled to interest. Now, my lord, here Lordship will kindly make a note. I paraphrase these submissions, my lord, to 3 facts. Number 1, the deposit in this case of 7 crore and odd was made pursuant to the order passed by Honorable Justice Moushumi Bhattacharya. Lordship has noted that in a 36(3), which was conditional to secure stay of the award on the principles of, my lord, Order 41, because, my lord, that is what the law says. Now, moment that is done, the question will be whether such a deposit is a deposit under Order 21, Rule 1 or not. Now, my lord, the test to that is, it can only be a deposit to Order 21, Rule 1, under Order 21, Rule 1. If, my lord, I am as a decree holder, my lord, I can have immediate access to that money. My lord, I do not have immediate access to that money. And, my lord, I had access to the money for the first time after the dismissal of Section 34. My lord, Lordship visualizes today a Section 30.
Court has given a distinction between a award and a decree also.
My lord?
Supreme Court in Sundaram has stated that the award and decree, maybe it's fictional to be a decree, but it's award is award. So the parameters which you're talking about, it might be different also.
No, my lord, is my lord thinking in terms of a distinction between award and decree?
To an extent, yes.
My lord, in my respectful submission, my lord, so far as execution is concerned, my lord, there is no distinction, because, my lord, all this is being, my lord, there are 2 applicable provisions in a limited capacity so far as an award is concerned. One is, my lord, by virtue of Section 36, the principles of Order 21. And second is by virtue of 36(3), the principles of Order 41. There are only 2 applicable provisions of the CPC. And, my lord, in my respectful submission, the submission that I am making based on the ratio of these 3 judgments, my lord, it cannot be different from the award, for an award, For the simple reason, my lord, kindly visualize the situation. Today, a section 34, my lord, if a deposit is made, may be disposed of in 1 year, 2 year, or 10 years. Now, if after 10 years, my lord, the decree holder gets the benefit of an award, my lord, can the question be that the judgment debtor will not replenish the further interest? Will it be a deposit within the principles of Order 21, Rule 1?
So when the initial deposit is made, it is with the interest, the entire interest. The issue whether the interest will run later on after the stay is something which we have to see.
Correct. Well, and that is the question which was before the Supreme Court in AIR 1968. Well, that issue is no longer, my lord, the res integra. It is settled now. Well, I take the extreme case because, my lord, when the amount is deposited, it is the awarded amount. Awarded amount has now been interpreted to include principal plus interest.
What's the point of staying an award? If your interest continues to accrue, what's the point of staying an award?
Well, it's the
whole idea of
well,
interim order.
it is the exact argument. Well, what's the point of staying a decree? Well, Order 41, Rule 5. Well, I ask this question. Well, I understand what is troubling your lordship. Well, I am answering it, well, straight away. Well, if I may paraphrase the question, if an appellate court stays a decree by asking the judgment debtor or the defendant to put in the entire principal with interest, the appeal is disposed of after 15 years. The decretal amount carries an interest of 12% per annum. The deposit is earning, my lord, interest at 7% per annum. My lord, can anyone say that the decree holder is deprived or has to be satisfied with that 7%? Answer is no. Based on, my lord, 1968 Supreme Court, the division bench of Delhi High Court and our court. Answer is no. So, my lord, if, my lord, this principle is applicable in case of decree, my lord, in my respectful submission, there cannot be a different law so far as award is concerned. Because otherwise, my lord, lordship sees what happens. My lord, the decree holder is not getting the benefit of the money in terms of Order 21, Rule 1. That is the only answer. Today, a Section 34 application, my lord, it can take any time between 1 year, 10 year or more.
And an application, get the money invested, you'll get 12%.
File an application for what? For taking out the money. Well, I have to put in a bank guarantee.
Bank guarantee, yes.
That is exactly what the Supreme Court has replicated, my lord. Kindly have a look at, my lord, 3 paragraphs of 1968 Supreme Court. That is the distinction Supreme Court is saying. It is not money readily available. That was the exact argument made in 1968 Supreme Court. That the money was lying in court. The decree holder could have filed an application and taken out the money. The Supreme Court said no.
Any other judgments?
Well, these are the 3 judgments.
That's it.
The example that if it's an MSME, 3 times the bank rate, 10 বছর পরে আমি ওটা পাবো, there is 3 times the bank rate, কোনো MSME পাবি না তাহলে।
Let him give it.
It is not interest on interest. He is taking.
Well, just a clarification. This is not interest on interest. And my lord, even the judgment of Gurmeet Singh, which my learned friend has cited, it recognizes the position that it is well open to the decree holder to adjust the deposited amount first against the principal and then claim interest. Well, that's the paragraph lordship will find. And well, the judgment has been distinguished by the Delhi High Court division bench.
Will be defeated.
Yes, next.
Now 15.
If you for the award holder, Lordship will remember, Mr. Ghosh had taken a point that if he, in an execution application, is only liable to file an affidavit, simple sitter, and say that I don't have any assets. Instead of filing and disclosing all the assets and properties of the judgment debtor, that he wanted to rely upon some judgments, that is why. I'm led by Mr. Mitram.
Any reply and all has been filed in here? No.
I have execution application filed. I have, in terms of your lordship's order, filed an affidavit. But the affidavit of assets which your lordship had directed, the lordship's predecessor or lordship had directed, my lord, is not an affidavit of assets in terms of the form. Now, why I didn't do it? Because I, in that affidavit, have said that neither do I reside within the territorial jurisdiction of this court, nor do I have any assets within the territorial jurisdiction of the court. The execution petition also does not disclose any asset of mine within the jurisdiction of this court. Hence, I said under 39(4) of the Civil Procedure Code, read with three judgments, which I am going to cite before your lordship, if your lordship kindly allows me, Lord, that once I take responsibility under oath, saying that I have nothing within jurisdiction and neither do I reside, my lord, possibly, my lord, the decree or the award has to be transferred under 39(4), the new amended 39(4), and my lord, the court, my lord, cannot possibly, my lord, ask me to file a total, my lord, affidavit of assets, which will be amounted to fishing of evidence. And because anyway, that order would also mean that your lordship is executing the decree, despite, my lord, having no jurisdiction to execute. But kindly takes the Code of Civil Procedure 1, once, my lord, 39, section 39. Section 39. Lord, kindly see, my lord, section 39, the court which, my lord, 38 also, my lord, I must place, my lord. A decree may be executed either by the court which passed it or by the court to which it is sent for execution. Not 39. The court which passed a decree may, on the application of the decree holder, send it for execution to another court of competent jurisdiction. My lord, A, if the person against whom the decree is passed actually and voluntarily resides or carries on
I think
business.
probably you're relying on 4, which is the newly.
My lord, that I'll straight away come to 4. Nothing in this section shall be deemed to authorize the court which passed a decree to execute such decree against any person or property outside the local limits of its jurisdiction. Now, but if that is the case, kindly, my lord, takes the execution application once before I go to the judgments. The execution application, my lord.
Which judgment are you relying on?
My lord, 3 judgments I have. One is, my lord, the Supreme Court decision of Mohit Bhargav, which, my lord, takes into account this amendment made to 39(4) and clearly says after this, the court has no discretion left. It has to transfer. My lord, may I first, my lord, cite that, my lord? That is, my lord, I have given all the judgments to my learned friend, my lord. To Judge Shekhadev.
So this academic exercise we have to do if they don't have any property within the territorial jurisdiction.
I only say there are maybe more than 2,000 districts in India.
Sir, the law pretty much is clear now.
Yes.
Right?
This court, if there is no property within the jurisdiction, this court cannot execute. The law is settled. But the question which begs an answer for my, the only provision is if I file here, because this is an award, transfer is not required. You can straight away go to the court and file it. I am not aware of the properties. Now, the award is passed.
Sitting here to find out, do
Yes.
a roving and fishing
No,
inquiry.
that's
to find out
the court has said. Because that is the reason you have to file in aid of execution. You have to file the asset. Then the decree holder will know where are the assets. Then only I can go to that court.
This academic exercise you want me to do, right?
That's what the Supreme Court and even division bench of our High Court has said. Not an exercise. Is only the asset must come in. Unless the asset comes.
This way you can file it anywhere and they'll be filing a affidavit of asset, giving the details of their asset. And then you file it in the...
Yes, that is the reason I'm filing here.
To interrupt,
because today, my lord, how do I know in which jurisdiction they have assets?
My lord, may I only answer your
Today,
my learned friend's query in one sentence, my lord. He does not have to go all over 22 districts of India. He has to go to where my principal registered office is. Yes, wherever Delhi. He has to go there, and I have to file my affidavit of assets there. Because my registered office is
Wherever
there.
the debtor is located, you have to file it over there. If you are not able to find any immovable property of the debtor anywhere else. That's what the law says.
Yes, but here, even Mohit Bhargav and Calcutta division bench is saying that you file an affidavit of asset. And then if a property is in Calcutta also, that from the box has to be ascertained.
He's not entitled to give all the details of the property of asset if it is not here. He's taking the ground. Actually, you can move an application.
I would
they should be dismissed.
I would be moving it. I was only
When application, I'll dismiss it.
Then I'll make an application. If he doesn't withdraw, I'll have to.
No, Lordship will decide this because unless
I will not decide this.
Unnecessarily.
There's no point. I'm not going to do this academic exercise unnecessarily. What's the point? You're wasting the time.
The other matter, he has already filed an execution in Delhi. He has filed in Delhi. Why this
If you're
academic
aware,
exercise?
please find out.
Yeah.
And ask your client not to waste
There,
my time.
it's there, my lord.
If he has filed it in Delhi,
Yes,
this
he
should
has.
be filed in Delhi too.
Not this one, the other one, connected one. I'm
The
saying
connected one, if he has filed it in Delhi,
It is same judgment data.
same judgment. Taki company,
Oh, same judgment data companies.
obviously.
Same
Why are you filing it there? And choose to file it here.
No, I choose to file it here because the arbitration took place here. The venue was in Calcutta. So that is the reason.
Waste my time.
No, I have to take instructions on this that already we have filed in one.
Please take instruction, then I'll decide it with cost.
One in Delhi. I'm not aware whether.
If you want me to do these academic exercises, then I'm going to decide it. You're wasting my time.
No, it's not that bad. I'm not. I just because once
You
I've
seek
gone there.
instruction and don't waste my time there. If you are filing it against the same debtor in different jurisdiction, don't file it here.
Again, the same detail. Same detail.
No. Obviously, the award holders will be different, my dear. My dear friend, award holders would be different. We are talking about the debtor. If the debtor doesn't have any property in this jurisdiction, how can you file it? He's not even located in this jurisdiction. You're filing this to do a roving and fishing inquiry where he filed the affidavit of asset, giving all the details, and then you'll file it in the different forum. Why should I carry out that exercise?
And once another.
Please take instruction. Yes. If you're filing it against the same debtor in Delhi, you file it in Delhi. Why are you filing it here?
We pull it against it.
Why waste the time of this court? When you know he has no asset. He's saying it on oath, he has no asset. It is not that he's not even saying it. He has filed an affidavit of asset saying I have no asset here. Then why should I compel him to file something else? For your academic exercise? I'll not do it. I'll not do it. I rather dismiss it with cost. But don't waste my time.
I'll take instructions. Once has been already been done in Delhi, there is no point against the same judgment date.
I'll ask him to file an application. I'll dismiss it.
Lordship is skipping it to next available next available date.
And I was also agreeable to get my client over here only to the extent that whether he has any asset within the West Bengal, Calcutta.
Will he swear something on oath?
Yes. No, he has given an affidavit, which I find that affidavit records there's nothing within.
Then why should I do this exercise?
No, I understand.
And your company itself is filing against them in different forums.
Me or
knowing very well.
May not be the same
Somebody
company
else.
with her.
Different.
Same sister company. Obliged.
My lordship, my senior is not present, so I'm praying for a short passover.
Is he coming also or not coming? Don't take a passover unnecessarily.
Okay, then Lord, not today.
Lordship, I appear for respondent number 1. By the last order, there was a direction given by your lordship to file affidavit of assets. I'm seeking for 2 weeks for filing the affidavit.
Why you are not filed it?
So there has been, your lordship, there has been delay on the.
You already got 3 weeks to file it.
Your lordship, if you could please grant us 2 more weeks.
Take down. Learned counsel for the award debtors seeks and is granted one last opportunity to file his affidavit of asset within a period of 2 weeks. List after 4 weeks.
For item number 17, I appear for the execution number.
No, 17.
I appear for the petitioner. But in this case, if your lordship looks at the order dated 5th of February, my lord had directed us to, my lord, have it served through the department. My lord, there are, my lord, 2 my lord, reports which have come. My lord, the last report, my lord, which was disclosed, my lord, on the last occasion, is that it's still not been served. despite us giving a different address. Now, my lord, this is the same address which was there in the pleadings of the arbitral proceedings also.
The department is
The
not able to effect the service, sir.
My lord, which is yes, my lord, I understand, my lord, which is why on the last occasion, this is the issue that my lord wanted me to make submission on, whether I come within the fold of Order 5, Rule 20 or not at this stage, so that I can, my lord, ask for substituted service.
Yes.
In this case, my lord, I had, my lord, looked up, my lord, two things, my lord, factually I'll have to make submission on. Number one is that the address which is mentioned in my execution petition is naturally the same as what was there in the pleadings of the arbitral proceeding in which the judgment debtor had participated. So there's no denying the fact that they had admitted that this was their address. Or even if it's not, I'm giving them the highest case, my lord. Even if it's not their address, at some stage this was. So now there's a change to they're naturally, my lord, evading service. So I was only praying if your lordship allows us, my lord, the leave to make substituted service, we'll make the paper publication and come back, my lord.
Come by next week, we'll see. Keep it next week.
Very well.
Next.
18. My lord, item number 18, this is my application, my lord. My lord, on the last occasion, my lord has directed the bank, my lord, my lord has basically restrained the respondent from operating their bank account to the tune of 1,19,46,278. I have served that order to the bank and the respondent as well. The bank has received and respondent has refused, as they have refused the main petition earlier. So this is my application.
Who has refused?
My lord.
Who has refused?
My lord, the respondent company and one of the partner and other partner is it is written there that addressee left without instruction and bank has received. On the last occasion also, my lord, the respondent has refused to take the
So we
copy
had
of the
already
application.
restrained them from operating the bank account.
Yes, yes.
Yes.
I have served the copy of the order to the bank as well as to the respondent.
Isn't he 34 or 36 pending?
No one.
They never challenged it.
No.
The award is what? Unilateral.
Award is not this award is, my lord, the MSME award, my lord, MSME arbitration.
Did they participate there?
No one. They did not. In that forum also, my lord, we had tried to serve the copy. They have sometimes they have refused, sometimes they have accepted.
It's an ex parte award.
Ex parte award. Thereafter, we had tried to serve them the copy of the application. My lord has also directed us to do that. We have done that, but they have not. They have refused, my lord. Refused to participate in these proceedings also.
Award starts from page.
My lord, the award starts from.
Where's the signed copy of the award?
No, this is a certified copy. I have.
You have to get the signed copy of the award, sir. On the certified copy.
Original award, my lord. I have filed, my lord.
Where is the virtual award? There's no signature.
Oh, original award is there. Original.
This is your certified copy of the award, right? With no signatures. Give it to him. Show this.
Oh, this is certificate.
Where are the signatures?
They have by post, my lord. They have this MSME department has sent this award to my client.
I'm not allowing this. You have to get the signed copy.
My lord, I shall.
We'll keep it next week. I'll give you the liberty to withdraw and file the award. Next week. Keep it next week. There's a judgment which I pronounced today
My lord.
on similar facts. MSME awards have to be signed to.
My lord, item number 23, my lord, would be lordship's pleasure to keep it as Thursday week. I have some personal difficulty in family.
They're on the other side.
My lord, we have taken their consent, my lord. Some religious, my lord.
All right. Item
Thurs-
23, keep it next week.
And before Lordship rises, my lord, item 15, my lord,
I'm
I've
grateful.
taken instruction, my lord, I'm ready to withdraw that, so, my lord, with liberty to file afresh, that execution application.
All right. Who's on the other side?
May I, my lord,
Just
call him at
inform them.
2 p.m.?
Yes, call him at
West, deeply.
আমার 23 থার্সডে উইক চাইছি 10 এপ্রিল তারিখটা
Next week?
Thursday week next week Thursday week next week
1 week after. Okay.
yes Thursday week yes I'm deeply obliged
Deeply.
And come back at 2 o'clock with the.
I'll call, I'll inform immediately.
Item number 15. Learned counsel for the petitioner. Learned counsel for the award holder seeks to withdraw the present petition with liberty to file appropriate proceedings in accordance with law. The present petition dismissed as withdrawn with the liberty as
Lord, the original award may be returned with the replaced with a certified copy.
order किया था मैं original award वाला वही करता same order.
Lord, may I pray for the same order in 101? That is the other matter where Vipul is, Lord, Mr. Ghosh is appearing in that matter also.
101.
Where we had filed in Delhi.
Same identical order.
Yes.
Award in that also, right?
Award is, yes.
You'll take the award with a certified.
Yes.
Certified copy, Xerox copy.
Xerox copy, Lord. Xerox copy, perhaps not certified.
Xerox copy. Xerox certified copy should be put in there. Xerox copy will not do. Xerox certified copy.
डिपार्टमेंट के बोले और नहीं करेगी
Yes.
Number 4.
Examination of judgment letter at number 104.
Directed to file report manner regarding the
Report regarding Mr. Pandey. What?
report. The warrant has been issued, manner. It appeared that the sheriff has no information regarding the education. So, my directed the sheriff to file a report. What happened to that?
He doesn't stay on the address. He has sold the property.
But I give liberty to go through the report of the sheriff manner, and I adjourn for 2 weeks. I have to take instruction from client manner. But find out the other addresses of the
Learned counsel for the petitioner. Award data. Award holder seeks and is granted liberty to go through the report filed by the sheriff, deputy sheriff. List after 2 weeks. Give him the report.
Rest of it. 105.
Lordship, today is fixed for examination of judgment letter number 2.
Lordship, I'm for judgment letter number. There had a talk of a settlement regarding the matter.
So we have no Lordship, we have no instructions for the settlement talks of
Not
settlement.
aware. Who are you talking to?
Lordship, the judgment letter had a talk with the award holders.
Lordship, unless
As for the award holder, they have no idea about any such settlement talks.
But
As it is, he should have been here. There's an order passed for him to be here.
yes, your Lordship, but as per the instruction, there is a talk of settlement.
Lordship, there is no communication.
I'm not concerned. Even if there's a talk for settlement, why is he not here? He should have been here.
Lordship, he is in Bangalore.
Wherever he is, madam, it doesn't matter. Do you understand what you're saying? There's an order passed by this court. He has to comply with the order. Where is, it doesn't matter he's in Bangalore or Timbuktu. Why he's not here?
Lordship,
We'll issue arrest warrant against him.
Lordship, kindly grant 4 weeks time.
Who's your senior?
I'm led by Miss Neha Datta.
Ask her to join. Ask her to come. I'll pass it over. These kind of instructions will not help me. Ask her to come.
Uh, 106. At now 106. EC 285 of 2024. 20.
Mr. Pandey, where is he? This is Sinha and Company. What happened? You're not there.
But I'm not looking there. Somebody else from my office.
Who's there in this?
Can you pass it over, my lord? I don't know about the matter, my lord.
None appears for the parties. Appears for the award holder or the judgment letter. The interest of justice adverse orders are deferred. List in the after 1 week. 2 weeks, sir. Just stop. 2 weeks.
And 7.
Yes.
107, I'm for the award holder, my lord. My lord, on the last occasion, by the order dated, my lord, 21st May, they have tendered an apology that the vehicle will be handed over to the receiver. But we have gotten letter from the receiver on 3rd of July that the same has not been handed over to the landed receiver, your lordship. My lord, on that basis, we have filed an contempt application. My lord, kindly, if your lordship take up the matter, take with this matter, my lord.
Contempt, where's the contempt?
My lord, I can give the number, my lord. You have already filed.
Get the contempt listed. We'll send him to jail for some time. He's the same gentleman. I know. He had appeared in this court.
Yes, your lordship. On the last date, he has appeared.
He's nasty. He doesn't have respect for the orders passed by this court. No, I know. I remember his face. Yes, he has no respect for orders being passed by this court. He gives undertaking to the court and then he flouts it. It doesn't matter, madam, whether it just doesn't matter. Any undertaking given to the court has to be complied with. Why? What do you mean pressurizing? That's not your job. That's your client's job.
You need to comply. For the compliance of the order
Madam,
passed
that's
by
not your job to pressurize your client. Your client should understand that, and he understands everything very well.
Yes, absolutely, your lordship. Absolutely.
We'll issue a arrest warrant against him. We'll send him to jail from here.
No, your
And the
lordship,
contempt
you don't
will.
pass the arrest warrant.
No, arrest warrant has to be passed.
And my lord, let the contempt application be appeared.
It's a perpetual.
Chance for a week, your lordship. This would be the last chance. It's my personal request before the bench. Please give us this last chance.
My lord, he has.
Undertaking.
My lord, kindly see the order dated, my lord.
Either you convince him or let me pass an order.
I will convince. Like we are convincing him from last.
You have failed. What's the point of asking for that relief?
My lord, kindly take the order dated, my lord, 21st May, my lord.
Look at him. Look at.
He has undertakes to hand over the vehicle, my lord, to the receiver.
Meantime, we'll find your lordship and we'll bring him in.
The receiver has already.
This person is not complying with the orders, and he has no respect for this court. I have seen him.
He will get scolded once he'll
No, it
appear,
doesn't
but
matter. He should go to jail for some time.
he should be
No, he should spend some time in the jail. Then only he will understand. He has no respect for the court. Warrants after warrants, and he does nothing. He comes here, gives an undertaking. Still, he will not comply with it. No, his body language itself shows that he has no respect.
My lord, my submission with your lordship, kindly, my lord, the contempt application. My lord,
I'll hold him in contempt. I'll send him for 6 months.
Well, I have filed it already. I've given the number, my lord.
List the contempt next week with this matter. I'll give you 1 week. You come back next Thursday and give the number.
I've
give the
already
contempt
given.
on the next date.
Gratefully.
Madam, I'm promising you,
Yes, Your
this kind of attitude is not correct. He should be taken to task. He's flouting the orders passed by this court from day one. There's so many orders. He keeps giving undertaking. He comes to the court and then he very conveniently ignores all the orders passed by this court. No mercy should be shown on him. He's a habitual. He has no respect for this court. And this also brings you in bad light also. And you're literally giving a personal guarantee, literally, that on my behalf, please give me 1 week. No, not to plead like this for somebody you know is defaulting.
If your lordship kindly see, the receiver has given a letter.
Not your job at all. You're absolutely wrong. You're first officer of the court. Be fair to the court.
Now, kindly see, the receiver has given me a letter that he has not handed over.
To file the contempt.
My lord. We have filed it, my lord. The number is grateful.
108.
For the award holder, Lordship, I'm praying for 3 weeks' time for issue of fresh service to the respondents.
You're praying for 3 weeks?
3 weeks' time to issue fresh service to the respondents.
Not been served.
My lord, I'm leading. My lord, the issue is this, my lord, respondent has already filed their affidavit of asset, but the advocate who is representing them, he is refusing service, saying that he doesn't have instruction. So your lordship has directed us to serve the respondent directly once again. My lord, that service is not complete.
All right. Learned counsel for the award holder. Takes and is granted. Further time of 3 weeks to effect service on the respondent. List on such date. After 4 weeks.
Lordship, in 109, I'm for the petitioner. On last occasion, the order was passed to file a report, police to file a report why the arrest has not been executed till date. This was the last order.
This is 20th March order.
20th March. Last order was 20th March, yes. And warrant of arrest was made on 11th December.
No report.
Lordship, in that case, fresh warrant may be issued.
The warrant of arrest issued earlier is extended till December 15, 2026. The Superintendent of Police and the officer in charge of the police station are directed to implement this order and ensure due execution of the warrant of arrest. and the production of the judgment data before this court on or before the returnable date. Despite directions to the Superintendent of Police dated 20th March 2026, no report has been filed, neither the warrant of arrest has been executed. The Superintendent of Police is directed to file a fresh report as to why warrant of arrest has not been executed, and the earlier orders passed by this court dated 20th March 2026 has not been complied with. Just after 4 weeks. A copy of this order shall be communicated by the Deputy Sheriff for necessary compliance. Report to be filed by the Deputy Sheriff on the next date. List after 4 weeks.
Grateful, Your Lordship.
In 110, there was an order passed by Your Lordship on 11th of June 2026, issuing an a warrant of arrest. Lordship, the person who has affirmed the affidavit has not been arrested. In fact, they've filed an application seeking recalling of that order.
May I? Milord,
And
my
you-
application is GA3. Milord, Milord, I will not try to justify Milord in any unfair conduct. Milord, on that particular day, Milord, what it appears, Milord, going through the petition, Milord, that is paragraph 7, if you Lordship, and he says, Milord, he usually follows a treatment, Milord, a doctor, Milord, in Patna, because he frequent, Milord, that place also relating to business. On that particular day, he is a heart patient, went there, Milord, he had to be admitted. One aspect is not there in the petition, but I must tell Your Lordship, Milord, what the learned advocate on record was doing. Milord, he himself, Milord, this is on instruction, he is here, suffering from viral fever. That day, Milord, it went unrepresented. My Lord was pleased to issue a, Milord, arrest warrant. Milord, for recalling of that, to get a chance, Milord, to make a representation before Your Lordship.
Not at all.
No,
Why
Your
should I
Lordship.
recall the order? There's no question. Where is he?
Well, he is here. And I have asked him to come before Your Lordship.
He's the concerned person
Milord, he is.
against whom the warrant was issued.
My.
Yes, tell him to take court. He's
Milord,
here. He surrenders before the court.
To let him be put in the dock, there's an affidavit of assets. I can start cross-examining him.
Milord, one humble request in that case.
GA3 not pressed.
Milord,
Dismissed as not
GA3
pressed.
He's already
Milord, for
present.
the purpose of Milord that. Milord,
Nothing.
he's surrendering after
He's
all.
surrendering, so why the
By GA3.
GA3 becomes infructuous?
Right.
Give him more.
Milord, one.
Sundaram.
বেঙ্গলি
আমি শপথপূর্বক বলছি
এই মামলায় সাক্ষ্য দিতে হবে
এই মামলায় সাক্ষ্য দিতে এসে
আমি যা বলবো সত্য বলবো
যা বলবো সত্য বলবো
সত্য বা মিথ্যা বলবো না
সত্য বই মিথ্যা বলবো না
কোনো কিছু গোপন করবো
কোনো কিছু গোপন করবো না
Milord, Lordship is
সুন্দরানন্দ
Milord,
বর্মন সুন্দরানন্দ বর্মন
examination of judgment data. Milord, I have, Milord, one, Milord, petition to place before Your Lordship, Milord.
Okay.
On last occasion, Milord, also I submitted, Milord,
Let
section
Ashutosh
34.
Burman.
No, it's a change brief, Milord, it was done by, Milord, the Astral advocate, Milord, those who were there. Milord, that is, Your Lordship's mind
45.
was very clear, Milord, until we pay and then
Business.
come before Your Lordship, following the judgment.
220/1 রায়পুর
No,
রোড
Milord, that cannot be taken out. That
Party?
cannot even be looked into. That was Your
220/1
Lordship's. Milord, we have taken out
Yes,
one
then let him first. I can't hear both. Give him the oath.
Oath administered.
Milord, oath probably, Milord,
Oath has been administered, Your Lordship, then.
Given the oath. Yes, tell me.
Milord, one application that we have taken up, that is under section scope of under section 47 of the CPC. On the simple point, one point agenda. Milord, if I,
47, you forget 47. Please.
Milord, that probably, Milord, Lordship, can you deal with that application, reject it, Milord?
Give it right now, I'll deal with it.
Fine. But I have taken only one point. My Lord, you kindly consider this.
Yes.
That if the decree is a nullity, I can
Yes,
take up
yes,
that
decree
point.
is a nullity.
My Lord, if my Lord,
Electro steel 47 decree is a nullity.
nullity, my
Give-
Lord,
give
then
me,
in that
I'll
case, my Lord,
decide
it is
the-
inexecutable. My Lord, that
Yes,
point.
yes.
My Lord, no document
why
has.
47 should be.
My Lord,
edited.
only
Tell
point
me.
is, Lord, you can consider.
Why is the award a nullity? Tell me.
My Lord,
Yes.
my Lord, it's a MSME award.
Yes, MSME.
Now, my Lord, for the purpose of MSME, my Lord, he needs to be registered with Uddam.
All right.
Now, my Lord, we sought for, my Lord, information, my Lord, by
Go in
way of a right to
34.
info, right to
Merit of the
information.
matter 34.
Grateful Lordship.
34. Go in the merit of the matter.
Assumption of jurisdiction, my Lord, assumption of jurisdiction by the, my Lord, court or, my Lord, the arbitration tribunal.
All right.
My Lord, it goes to the root.
Which
My Lord,
page? Which?
my Lord is taken up, my Lord,
Yes, 47
GA2.
GA2. Yes. What are the grounds? Tell me the grounds.
My Lord, that is the only ground. My Lord, I'll refer to, my Lord, only one writing, my
Arey,
Lord,
where
that
have
page.
you mentioned the ground in your petition GA2 application? Where is the ground?
My
Which paragraph?
My Lord. It to volume 2, volume 1 koi. Yeah, next chapter. Paragraph 25. Annexure N. Annexure N. N for Nagpur. 24 and 25, only these two.
24
and 25. Right to information, I sought for, my Lord, whether it is, but the reply by the authority, it is not. This is the position, my Lord, as of today. So far, my Lord, my capability goes, I have gone through the award. In the award, my Lord, I haven't found the document, my Lord, that is with me. That, my Lord, it has been mentioned that this is registered, and here is the number, my Lord, that, my Lord, the registration number with the Uddam. That is the only point.
You raised that plea in 34?
Grateful Lordship.
No, 34, in all probability, that plea is there. But what I find,
Very
my
good.
Lord,
That plea is there in 34? Right?
my Lord, I have not looked into that application because, my Lord, I considered, my Lord, that is not maintainable. That's why I have come up with this, my Lord, only limited to. But this was agitated before the arbitration tribunal itself.
Take down.
Later on.
Application. The present application has been filed under section 47 of the
My Lord, can you once
arbitration and
consider, my Lord,
conciliation
page 240.
seeking the interference of this court at the stage of execution petition. Full stop. The contention of the petition is the award letter is that the award is a nullity in the eyes of law since the
That the person is not a supplier under section 2N.
You're the award debtor, right?
Yes, award
The
debtor.
award debtor, it is stated that is not registered with the MSME authorities.
No, award holder is not registered. But I am the award debtor.
Award holder is not registered.
Award holder is and
stated that the
he is
award
not
holder,
a supplier under section 2N.
that the award holder is not registered with the MSME authorities and that he is not a supplier under section within the meaning of section 2N of the Micro, Small, Medium Enterprises Development Act 2006. You are relying on some judgment, Electro Steel?
My Lord.
Learned counsel for the award debtor relies on the judgment of the
2023 volume 6 Supreme Court cases 401.
Electro Steel.
Millard Gujarat State Civil Supplies Corporation.
Give me on such and such judgment.
And
it is noted that the narrow compass under which this court can interfere
paragraph
under
number
section
I have
47 is when the award is honest or a nullity in the eye of law. Full stop. In the present facts of the case, the award debtor has already preferred a section 34 petition, and that to say that the MSME council had no authority to pass an award since the award holder was not a supplier within the meaning of Section 2N of the MSME Act 2006, goes to the root of the award. And at this stage, this court cannot adjudicate
a judgment
on the issue of the award being a nullity on this limited ground. And thus the present application under Section 47 is dismissed.
My lord, two judgments, my lord.
The judgments, I'll quote all the judgments.
It. 2021 will seal P.
Yes.
Paragraph 26.
This has become a new trend. Yes, now tell me. 47 goes, your GA2 dismissed, GA3 dismissed. What else is there?
Well, nothing else. My lord, kindly.
Yes.
You may cross-examine.
Only time I can seek, my lord.
No,
give
no,
up.
Your Lordship, I'm opposing.
You can keep filing appeals.
Shown affidavit of assets dated 2nd of September 2025. Shown page 3 করে দিন, shown page 3 of the affidavit of assets.
Yes.
Bank account যেখানে দেওয়া আছে।
Have they filed a 36?
They filed a 34 way back in 2024, never moved. They've not even filed a 36. They've not even filed a 36. 34 is not even admitted.
What is there to attach?
Lordship will kindly see page 3. They've disclosed a cash, they've disclosed a bank account containing a balance of 3 crores 85 lakhs.
Where is it?
Affidavit of assets, kindly. Amount bata. 192. And this is as on 31st of March 2025.
How much is the awarded amount?
Lordship, the awarded amount is 5.62 crores. In 190 and 191, it's 9.26 crores. This is at the time of filing of the execution. The company has sufficient assets. They're doing contract worth crores. Do you find that the balance in your bank account is around 3 crores 85 lakhs? Do you also find that this balance is as on 31st of March 2025? Can you provide the updated bank account statement of the company?
এখন তো পারবো না।
Next date.
নেক্সট ডেটটা দিয়ে দিতে হবে।
Yes.
Yes, I can.
How many employees does the judgment debtor have?
27, 27, 28.
Around 27.
How does the company pay these employees?
তাদেরকে পে করে টাকা দেয়।
ওটা HR দেখে।
This is looking after by the HR department.
What is your position in the company?
আমি ডাইরেক্টর ছিলাম।
I was a director.
What do you mean by I inverted commas? I was a director inverted comma close.
আপনি ছিলেন তার মানে কি বলতে চাইছেন?
না আমি ডাইরেক্টর আছি। হ্যাঁ কোনো
At
ডাইরেক্টর।
present, I am also a director.
So I presume that the HR department comes under your scope and work as a director.
তাহলে আপনার HR ডিপার্টমেন্ট যেটা বললেন সেটা আপনার আন্ডারে কাজ করে অ্যাজ এ ডিরেক্টর আপনি। Yes.
So kindly provide the manner in which these employees are paid on the next date.
পরের ডেটে কিভাবে তাদের এমপ্লয়িদেরকে কিভাবে টাকা দেওয়া হয় সেটা আপনি করে দেখাতে পারবেন। Yes.
Does the company have any other contracts with any other running contracts with other companies?
না।
No.
Are you aware of Damodar Valley Corporation?
আপনি জানেন? Yes.
Do you have any running contract with Damodar Valley Corporation?
না আরবিট্রেশন চলছে।
No, there is a arbitration going on.
In such, what is the claim in such arbitration? Sorry, Kededi. How is the judgment debtor connected to such arbitration?
আর্বিট্রেশনের সাথে কিভাবে যুক্ত এই জাজমেন্ট লেটার কোম্পানি?
কাজ করানো একটা গন্ডগোল হয়েছিল, এর বেশি আমি এটা বলতে পারবো না।
There is a misconduct in the work. I cannot say further about this litigation.
Is the
কিন্তু এটা এখন স্টপ আছে।
But now it is under
আরবিট্রেশন এখন স্টপ আছে, হাইকোর্টে চলছে।
Is the judgment debtor
arbitration is pending before the honorable court.
is the judgment debtor the claimant in such arbitration?
এই আর্বিট্রেশনে ক্লেম করছে মানে তারা
যারা যে কন্ট্রাক্টর কাজ করেছিল তারা ক্লেম করেছে।
the contractor who had done the job, they have claimed.
I suggest to you that the judgment debtor is itself the contractor in such arbitration.
আপনাকে সাজেশন দিচ্ছি, আপনি মানতে পারেন নাও মানতে পারেন। বলছেন যে জাজমেন্ট লেটার কোম্পানি মানে যেটা আপনারাই কন্ট্রাক্টর।
আমরা কাজ নিয়ে কাজ করেছে অন্য কোম্পানি, তাদের সঙ্গে টাইপার্টেড এগ্রিমেন্ট ছিল। আমি সে কপি দিয়ে দেবো।
Yes, we are the contractor, but we did not done the job. Some other contractor done the job, and I have the copy. I can provide the copy before the honorable court on the next day.
Shown page 4 of the affidavit of assets. What happened to কেটে দিন. Is this Pajero Sport bearing registration number WB08 capital A 4231 still owned by the company?
Yes.
How is the said car insured?
This car is insured.
How is the said car insured? মানে আপনি ইন্স্যুরেন্স কিভাবে করেন?
কোম্পানির নামে আছে গাড়ি।
The car is registered in the name of the company. কিভাবে রেজিস্ট্রেশন?
না ঠিক আছে. I presume then the insurance charges are also paid by the company?
ইন্স্যুরেন্স কোম্পানি দেয় তো? Yes.
I also presume that all the expenses relating to such car are paid by the company?
এই কারে যা কিছু যাবতীয় খরচা সেটা
আমি
সব
দেখতে হবে, কোম্পানি থেকে সব করে আই থিঙ্ক।
I have to check.
I suggest to you that despite having the money in your bank account, you have deliberately not satisfied the awarded amount to the petitioner.
সাজেশন দেওয়া হচ্ছে, আপনি মানতে পারেন নাও মানতে পারেন। আপনার ব্যাংক অ্যাকাউন্টে যথেষ্ট টাকা আছে এবং আপনি ইচ্ছাকৃতভাবে এই যে টাকাটা যেটা পাবে সেটা আপনি ইচ্ছাকৃতভাবে দিচ্ছেন।
না না না
I disagree.
Then why have you not paid the awarded sum? Then why have you not paid the awarded sum?
কেন টাকাটা দেননি কেন?
তো উনি কাজটা করেনি।
বিকজ কে
কার টাকার কথা বলছেন? ওই যে
তাহলে আপনি টাকাটা দিচ্ছেন না কেন? এই যে কোম্পানি যেটা পাবে সেই টাকাটা তাহলে
উনি কাজ করেনি অ্যাকচুয়ালি, ওনার কাজ করেনি বলে কাজটা আমার কাছ থেকে গভর্নমেন্ট টার্মিনেট করে নিয়ে নেয়। আমি আবার কোর্ট থেকে অ্যাপিল করে কাজটাকে তুলি।
the company did not done the job, so the কি ইয়ে আপনার কি বলেন কি জব that is why the
এই কোম্পানিতে
taken back the job from me.
দেন আবার হাইকোর্ট করে আমি ওই কাজটা নিয়ে এসে আমরা নিজেরা পেমেন্ট করি
We have filed a case before this honorable high court and get back the job.
এবং প্রতিটা কন্ট্রাক্টরকে আমরা আমাদের কোম্পানির অ্যাকাউন্ট থেকে পেমেন্ট করিয়ে কাজটাকে শেষ করি।
And we have finished the job
উনি
by paying the money from our company's bank account to the laborer and finish the job.
এবং সেটা পুরোটা আমরা অ্যাকাউন্টেই পেমেন্ট করেছি। আর উনি যেটা দেখিয়েছে পরে আমি জেনেছি সব ক্যাশ ভাউচার দেখিয়েছে।
একবারে বলবো।
ও
And we have paid all the labor charges from our company's bank account.
সমস্ত কন্ট্রাক্টরকে আমরাই আবার অ্যাকাউন্টে পেমেন্ট করে কাজটা করেছি,
And we have
কারণ ওটা খুব সেনসিটিভ কাজ ছিল।
Does he understand? There's an award. Does he understand there's an award which he has to satisfy? Whether somebody has done work, not done work is not the concern. There's already that has been decided.
He
There's a
understands.
quantified amount which he has to pay in terms of the award. His understanding is wrong.
He is giving his own case, my lord. What your lordship is saying, my lord, he understands probably what he is saying his case, my lord.
आप यहाँ क्यों खड़े हो?
सर
एक अवार्ड पास हुआ है ना?
हाँ सर।
अवार्ड में आपको पेमेंट करना है?
हाँ सर, और बाद में मुझे पता चला सर।
जो भी है वो आपको पेमेंट आज के दिन में आपके ऊपर है ना, वो आपको करना है। वो काम किया है नहीं किया है ये सब मेरिट की बात है।
सर मुझे पूछा, सॉरी सर।
आप अवार्ड में पेमेंट क्यों नहीं कर रहे हो वो बताओ। आपके खिलाफ जो আপনার है ना মানে আপনি মামলা করেছে যে একটা অ্যামাউন্ট টাকা আপনাকে এতটা ওটা পাবে সেই টাকাটা আপনি কেন দিচ্ছেন না?
কারণ স্যার এইটা নিয়ে ওরা 6টা 7টা কেস করেছে, আমি সবগুলোকে আমাকে করতে হবে মানে কোম্পানি
Yeah, diyechen, and let me ask further question. Are you aware that an award dated 16th of December 2022 has been passed against you, against the company?
আমি রিসেন্টলি কিছুদিন আগে জানতে পেরেছিলাম পুরোটাই।
I have come to know about this few days ago.
মানে যখন কেস করে হাইকোর্টে তখন আমি জানি।
Are you aware that
When the case was filed before the honorable court, at that point of time, I came to know about the case.
Are you aware that the judgment debtor itself had filed an application under Section 34 of the Arbitration and Conciliation Act 1996 way back in 2024?
হাইকোর্টে কেসের সময় আমি জেনেছি, সেটাই তো বললাম।
না না উনি বলতে চাইছেন আপনি কি জানেন যে জাজমেন্ট এটা কোম্পানি মানে আপনারা একটা আরবিট্রেশন অ্যাক্টে মামলা করেছেন তার ইয়েতে জাস্ট 2024 সালে।
কোন মামলাটা?
আপনি ওভাবে জিজ্ঞাসা করতে পারবেন না।
You cannot, whatever you
আচ্ছা
can recollect, you
ঠিক আছে।
I cannot recollect.
I suggest to you that you yourself, on behalf of the judgment debtor, had filed an application under Section 34 of Arbitration and Conciliation Act, affirmed on 11th of December 2023,
অফিস থেকে যেটা দেওয়া হয়েছে
which was, just a second, which was numbered as AP 864 of 2023, I'm sorry, 858 of 2023. 858.
উনি বলছেন যে আপনি এবং এই যে আপনি জাজমেন্ট একটা কোম্পানি যেটা আপনারা মিলে একটা মামলা
একটা
ফাইল
হাইকোর্টে
করেছে
করা হয়েছিল, হ্যাঁ।
যেটা 11/12/2023 সালে যার
ডেটটা আমার
নাম্বার
মনে
হচ্ছে
নেই, এটাও আমার মনে নেই।
আরবিট্রেশন পিটিশন এপি 858 of 2023.
এটা আমার এই নাম্বারটা আমার মনে নেই, তবে একটা আমরা ফাইল করেছিলাম, এটা
I
মনে নেই।
cannot recollect the number, but we have filed a arbitration petition.
Therefore, I take it that at least on 11th of December 2023, you were aware of the passing of the said award.
তার মানে উনি বলছেন যে তাহলে আপনি জানতেন যে 11/12/2023 যে ডেটে আপনি মামলাটা ফাইল করেছিলেন, তাহলে আপনি জানতেন এই অ্যামাউন্ট ব্যাপারে।
এমএসএমের একটা, কিন্তু তারপরে অনেকগুলো কেস একের পর এক উনি করে রেখেছিল, সেগুলো চলছে।
না না, উনি বলতে চাইছেন 11/12/2023 যখন আপনি অ্যাপ্লিকেশন পিটিশনটা ফাইল করেছেন, তখন আপনি জানতেন যে তাহলে এত টাকা যে কোম্পানি যে আপনার মানে
ওই ডেটে আপনি জানতেন যে এই অ্যাওয়ার্ডটা পাস হয়েছে।
আপনার রেজিস্টার।
ইয়েস।
Then why have you not satisfied such award till date, despite having the money?
তাহলে আপনি আজ পর্যন্ত আপনার কাছে টাকা থাকা সত্ত্বেও তাহলে আপনি এখনো পর্যন্ত কেন টাকাটা পেমেন্ট করেন?
এটা কেস চলছে তো, আর 3-4টে কেস চলছে তো, এটা নিয়ে 3-4টে কেস চলছে।
What did he say?
As the case is undergoing.
Are you aware that your application under Section 34 of the Arbitration and Conciliation Act 1996 has not even been admitted by this court?
আপনি যে মামলাটা যেটা করেছেন যে আরবিট্রেশন অ্যাক্ট 34 1996 এ, সেই মামলাটা এখনো পর্যন্ত গৃহীত হয়নি কি দেখা?
না,
I don't know. Do you have the 34 petition?
I have the 34 order.
Do you have the 34 petition?
I don't have, not one application, Milord, I have got. Seems, Milord, it's under section 36(2). 36. Should be 36, Milord, that's caption line.
This is the order I've asked for the
Brief,
petition.
Milord, the difficulty, Milord.
This is the order then.
But 47 is your idea.
Right.
That's a brilliant idea.
In fact, this is the third set of advocates appearing.
Everybody will come and file one application.
So we have called for the 34 petition as well.
We should dismiss these applications with cost.
Milord, these applications, Milord,
Should be dismissed with cost.
Milord, really.
You file a 34, then you file after 2 years, you get up. One brilliant idea comes into somebody's mind, then files a 47.
Milord, you kindly consider this. Milord, 34, 36, whatever, Milord, was in the award, Milord, they have talked about in all probability and Milord challenged it.
What is the ground? Have you read 34?
No.
Why? You are the lawyer concerned.
Milord, I am.
You are handling the brief today.
Milord,
Then
because
what are the
because of
grounds
the fact, Milord,
What are the grounds in
Milord, they are usual, Milord, that the arbitrator has not applied his mind. Right now, Milord, 36, Milord, I was going through. Now, Milord, like those. But, Milord, considering, Milord, the procedural difficulty, it's a, Milord, thing, Milord, that I cannot open before your lordship. Milord, I didn't want to, Milord, waste your lordship's time.
But you have wasted my time.
Milord, only with regard to a point which, Milord, has come up, Milord, later. Milord, that information that we have obtained, Milord, during the pendency of this proceeding, Milord, that's by way of that petition, Milord, I have brought before your lordship.
File a supplementary affidavit in your 34.
Could have been.
Then why are you pressing this application?
Milord, because of the fact, Milord, that hits to the root, Milord, the
That
very,
hits to your 34 also.
Milord,
File a
very
supplementary.
maintainability, Milord.
File your supplementary there.
I shall. But in the meantime, Milord, my lord has already dealt with, Milord, my application, Milord.
You withdraw this application. File a supplementary.
Milord, as of today, Milord, that application, Milord, I have come up before your lordship
That's what I'm saying.
after obtaining, Milord, the information.
After obtaining information, file a supplementary. So that ground is there.
Milord, that, Milord, will be an additional ground, Milord, to my application under section 34. Milord, so far, Milord, this application is concerned, Milord, lordship kindly, my lord has been pleased to deal
I'll
with.
dismiss the application with a cost of 50,000 for wasting my time.
Lordship, the section 34 is with your lordship's court officer because it's also there in the list.
Thana 34.
Lordship will see if that order thereafter they've not even appeared. no steps taken. Order গুলো দেখে দিন তো।
I found, my lord, after
Lordship,
couple
order
of
গুলো
them,
দেখে দিন।
my lord, an application before the same
You don't
tribunal
want-
was moved.
You don't want to deposit, have you deposited 75%?
No, my lord, that's the whole difficulty.
They've not
That's
even
the
filed a
reason-
36.
That is the reason you have filed this 47. That is why you have filed it.
Lordship message.
All right, dismiss with the cost of 1 lakh rupees.
My lord,
At least.
Grateful.
No, I know.
Lordship, 34 they never move. They don't file a 36. I file an execution petition. Repeated chance they have filed an affidavit of assets. Thereafter they don't appear. Thereafter your lordship was pleased to
yes,
issue
my
an
lord,
warrant for
my
arrest.
lord, considering
This is-
my lord, what has
and
gone
I'll-
by,
I'll-
my
I'll
lord,
record
my
everything.
conduct is very bad.
No, your
My lord-
conduct, I'll record your conduct. Till now, I have not recorded the conduct.
My lord, kindly consider this, my lord.
No, I'll record
Even-
the conduct.
My lord, to the
Give me
extent, my lord,
34
we have been able to
Hey,
ascertain.
Give me 34. I have to deal with this. I'll impose exemplary cost on this.
Lord,
I know why you're doing this.
What I am submitting before your lordship, my lord,
Give 34.
award, my lord, before the learned arbitrator itself, my lord, that ground was taken. Now, my lord, even then, my lord, if the petitioner before your lordship,
No, I'll record that because you don't want to make the pre-deposit under 19, you have filed this application.
my lord, if I found, my lord, a proceeding, my lord, which is otherwise not mentionable, inherently lacking jurisdiction, am I barred, my lord, from taking that point before the court?
Mr. Ghosh,
My lord. My lord, it's a question of law.
be
My lord, it's a
careful
question.
when you make these
My lord,
statements.
my lord, I am, my lord, that question to pose to myself. My lord, I am saying, my
Don't
lord,
pose
that,
too many questions to yourself.
my lord, that, my lord, really went through my mind. My lord, that's a very, very basic thing, my lord, that should have been satisfied by the arbitrator itself. The arbitration
That
tribunal,
goes to the root of the matter.
yes.
That can be decided in your 34, not in your 47 application. We are not going to start this trend of 47 where anybody can challenge the award. The whole Arbitration Act will collapse.
My lord, only in the ground, my lord, if it's a nullity, otherwise not. My lord, I have not addressed the matter on
Issue of
merit.
nullity is a very narrow compass, Mr.
Yes, on narrow compass.
And this doesn't fit into that compass.
My lord, I have not, my lord, on merit. সেকশন 34 দেখছেন মাঝে মাঝে বকে লাভ আছে
On the list.
এটা 86
You have not filed a reply to the 47, no?
No, your lordship. It was never pressed.
This was never pressed.
Never pressed, your lordship.
They are
Lordship will
only
see the
filing.
previous orders.
Which one?
47. যেটা আপনি আজকে বললেন
Can you do one thing? File your reply, we'll dismiss it with cost. If I just simply dismiss it, it will not capture the conduct of the
very well, lordship.
of the file your reply to this within 1 week.
Lordship.
We'll keep it after 2 weeks. We'll finish it. ये 47 का लिखो. The petitioner, वो GA2. GA2. The petitioner has filed the award debtor has filed the present application under section 47 of the Arbitration and Conciliation Act, stating that the award dated 16/12/2022 is a nullity. Full stop. Learned counsel for the award holder states that the present application is not maintainable since the petitioner had already challenged the award dated 16/12/2022. He further states that after filing of the said award under Section 34 of the Arbitration Conciliation Act, the petitioner has not taken any steps to get the matter listed. Full stop. Learned counsel for the award holder further states that the petitioner has not deposited 75% of the awarded amount in terms of Section 19 of the MSME Act for the matter to be heard. Full stop. He further states that the present application has been filed to scuttle the deposit
I'll
of
kindly,
the,
my lord,
to deposit
that,
the,
my lord, if you lord.
I'm just recording his submission. I'll deal with it.
Right.
To scuttle the deposit of the amount as mandated under Section 19 of the MSME Act. Full stop. He seeks and is granted 1 week time to file his reply. Affidavit in opposition, reply to the same within 1 week thereafter, list this matter right after 2 weeks.
My lord, GA2, my lord, has been
GA2.
3, my lord, is, my lord, that has become infructuous, my lord.
That has become infructuous.
So, your lordship, at this stage, may I pray for prayer D of my tabular statement?
Yes.
For injuncting him from using his bank accounts without
Yes. Prayer D.
prayer D.
EC में डालो. Prayer D. Of the tabular statement as prayed for is granted. The award debtor is restrained. वो देना उसका affidavit.
One humble prayer, my lord, may I make.
Yes.
My lord, it's not right now, my lord, to my instruction, my lord, doing a great business, but it's a going concern. My lord, kindly keep that in mind.
Secure the money. Secure the money. I'll stop it.
My lord, so for that part is concerned,
Secure the money.
give me 2 days time to come back, my lord, taking instruction.
Let him
So
secure
that
it
part-
with your lordship.
Only prayer B, my lord, I am saying. Otherwise, my lord, whatever your lordship has said.
You
Only prayer
secure
B,
the money. You
2
are.
days, 2 days after
Look at
this.
the conduct.
My lord,
2022
I shall-
award.
Now, my lord, I am here. My lord, I shall
24,
try to.
You file 34.
My
You
lord.
know you have to make 75% deposit. You don't do it. Smartly, you move an application under 47 just to avoid and scuttle that payment of 75%. And today, you don't want that I should stay this.
No,
I
my
should,
lord, what I am saying, my lord has been pleased to observe. My lord has been pleased to observe.
22 to 26, what is the protection which is there?
My lord, whatever has fallen.
And the
from your lordship, my lord,
understanding which just this gentleman has of the award
Yes.
is completely contrary to law. Whether he has done work, he has not done work is absolutely secondary. We are not concerned. We are sitting in execution.
Absolutely. You know, that
Whatever
part,
the
that
award
part,
is,
my lord, I'll not.
right, wrong, whatever, I'm not concerned.
My lord.
I have to get the award executed. That's my task.
Subject to, my lord, finding, my lord, subject to finding, my
Red-
lord, if it is not.
red,
My lord, D, my lord, I am seeking, my lord, give me 2 days time. My lord, since 22, we have not done so much damage, my lord. As of today, my learned friend has examined the accounts. My lord, 2 days, Monday, my lord, lordship, keep it Monday, my lord, to secure the money, that part. My lord, it's a going concern, that's why I'm saying.
You should have thought of this earlier also.
My lord.
Growing concern is trying to get all kinds of ways.
I'll not try to justify that part. I'll not try to justify that. Only, my lord, as it has fallen from your lordship, my lord, to seek instruction. Apart from, my lord,
It has not fallen from me to seek instruction.
My lord.
You are saying that you want to seek instruction.
my lord, I.
You
See,
come back,
seeking instruction is my part.
come
My lord,
back tomorrow.
my lord has been pleased to say, my lord, to
Come back
secure,
tomorrow.
you know, on Monday. My lord,
Monday?
instead of Friday, my lord, on Monday. My lord, let us have the weekend, my lord, that's
Why you need to have a good weekend?
No,
And what about the award holder?
only, my lord, to take the
Who's
instruction,
not
my lord.
getting any
And
money?
he also, my lord, to manage the money, my lord, so much of, my lord, lordship
He
kindly.
has the money.
Lordship kindly. My lord, only on Monday.
Then we'll do nothing today then. we'll keep this matter.
Affidavit direction
In
it is all right.
junction
Affidavit direction will
is something from 2022 to 2026. Not a single penny, no injunction.
so long. But
Let
Friday
him
and
secure it
Monday
with your
will be
lordship,
coming.
registrar original side. I do not have any difficulty.
Secure the entire amount.
Grateful.
But if they are ready to make the deposit,
Very well, lordship.
let them make the deposit by Monday. Monday they'll give a undertaking. If they do that, we'll do that. 47, what do we do with your 47?
And let the affidavit, let my landed friend say, my lord.
Mr. Ghosh,
Your lordship has
telling you.
cleared your lordship's mind. My lord, I'll be burdened. My lord, I'll be burdened with cost. My lord, I have understood. My lord, the thing is that, my lord, at the same time, I'll pray before your lordship.
You're burdening me, so I'll burden you.
My lord also kindly take into consideration. My lord, party went before a forum without having the basic requirement, obtained an award. One day without giving adjournment for a day when I was not present. Lord lordship also keep this in mind.
Merit of the matter.
Merit of the matter.
Get your 34 heard.
My lord, the technicalities.
Before this court, deposit your 75%. We'll hear your 34.
Shall try. If possible, my lord, if at all, my lord, he is.
If that is the case, you deposit your money. We'll hear your 34.
Let me see. But my lord, let them also come up with, my lord, affidavit, what is their situation. Whether, my lord, they are at all registered.
If that affidavit comes.
My lord. If they registered, my lord, I don't have a case.
Whether they are registered, not registered.
My lord.
34.
My lord.
I'm not.
Yes, my lord, I have got your
into
lordship. Instead of 47, you go for 34.
Exactly.
My lord, procedure.
Absolutely.
My lord, kindly also at the same time. My lord, I appreciate, my lord, it's a arbitration proceeding. I have suffered an award. My lord is on arbitration procedure. But at the same time, my lord, if I can satisfy your lordship, my lord, there was no ground of that party going before that.
Ground, take it before 34. The moment you use the ground, 34. Not 47. I'm not going to
lordship knows, my
open
lord,
this
MSME
door.
three times the amount. Now, my lord, 3 times the amount. Out of that, my lord, 75%.
And 5 times of the bank rate.
And 5 times of the bank.
Yes.
My lord.
That is
My
what
lord,
it is.
That benefit
That is
someone
what
is
you
taking.
don't want to pay and you want your 47 to be heard. So we will add that 5 times to the cost. When I
My lord, kindly
and
have
I'll put it.
some mercy at the same time,
That
my
is the
lord.
reason why I've recorded. You're just trying to scuttle that 19, the mandatory provision, by filing this 47. Nothing else.
Let me come back on Monday.
Lordship, one humble request. Instead of Monday, if it could be Tuesday, subject to your lordship's convenience.
Tuesday.
Tuesday.
He'll be more than happy. Look at the smile on his face.
Monday, I have some personal difficulty.
Then we'll have it on Thursday only then.
Very well, Lordship.
Next Thursday.
Great.
Lordship,
Just keep it up.
the next item, 111, here, your Lordship, the case is even strong. There's no 34 also. Item 111.
Mr. Ghosh, what happened?
My lord, I have been told. So far, my lord, the earlier set of advocates are concerned, my lord, that was not filed. My landed friend has, my lord, got it ready, my lord. It has been affirmed. It is on the my lord, process of being filed.
Lordship, 34 of 2022 award in 2026. Lordship, this is just a mockery.
Maintainable? Huh?
Far beyond, my lord, 90 days, but my lord, that explanation will give.
How can the court entertain it? Where is the condemnation for that? Do you have the power to condone? Mr. Ghosh, you tell.
My lord, the reason, my lord, I have been told, my lord,
Whatever
from
is
the date of getting the copy, my lord, that copy, my lord, my landed friend says, my lord, was not such for that party is concerned. This is, my lord, on instruction. That he has obtained, my lord, only few days back.
File 47 in that also.
They have filed a 47 in that as well. There's a GA appearing before your Lordship.
I'll not
GA 2 and 3.
really, my lord, I'll not deliberate on that.
Item
My lord,
number?
whatever order has been passed
Next
in
item,
this,
Lordship,
my lord, let that.
111.
Usme bhi GA, what is the GA?
GA 2 is section 47, GA 3 is recalling of the warrant.
Same thing.
That is gone.
Same order.
Now here, your Lordship, there's no embargo for your Lordship to ask him to secure the amount. Subject to what? There's no embargo. There's not even a 34 on record. So my learned friend submission is neither here nor there. Whether it's affirmed, there's no.
What will you do that in that one?
My lord, it has fallen from your lordship, my lord, to secure the amount. My lord, I shall take, my lord, what can be the process, my lord, what is not, which, my lord, at the same time, my lord, serves the purpose and will not inconvenient for us also.
Your Lordship will kindly record his submission that he will take instructions to secure the amount in 111 because there's no embargo here.
They didn't have to. My lord, kindly have faith, my lord. On Thursday we are coming.
That faith I have, but
Very well.
with your 47, it has shaken that faith a little.
My lord.
All right. Thursday then, next Thursday.
Lordship, the same order as in GA2 in this as well.
GA 12. 1 week, then we'll have it.
GA3 to dispose of Ferdinand since he's appearing.
Then we can have it after 3 weeks itself. The entire
As your Lordship pleases, I was just concerned, your Lordship, if at least in 111, let him secure the amount.
after 3 weeks, we'll decide your 47.
As your Lordship pleases, I have no
Keep it after
difficulties,
3
but
weeks. 1 week, 1 week.
your Lordship, I would humbly press in 111 at least there should be a direction of security. There's no embargo, no 34, no 36.
Going away.
Which is 2022. Your Lordship, there are documents. I will confront him with that. But your Lordship, it's not that my
the
witness is.
My lord, we have, my lord, impressed upon him to appear before your lordship. My lord, at least, my lord, my learned friend, my lord, appreciate that.
All right, now Mr. Ghosh is there. At least settle it if you can't handle it.
Lord, let us see. So,
look at the way it has been handled. After 3 weeks, keep it after 3 weeks.
Grateful.
Should I keep it along with your 34 also?
My lord.
Lordship, 34, I believe your Lordship takes on some other day. Lordship can list the 34. I have no difficulties.
Yeah, 34.
Grateful.
There's a Passover matter, item 105.
105. What is that? What at Tata
Should
Cap?
ask the advocate on record of the judgment debtor to appear.
Lordship.
Yes.
Yes, Lordship, I apologize for my non-appearance, Lordship. Lordship, in regard to this matter, Lordship, a genuine proposal has been sent before the Bank of Israel's, and on 24th.
Show me the proposal.
Lordship, that has
Show
not
me
been
the proposal which you are saying.
Lordship, I do not have the copy, Lordship, but it has been sent, Lordship, on 23rd July, Lordship.
Why
and
you not?
they have not accepted with the received copy. We have not got
Then
the
there is
received
no
copy.
there is no settlement in that way.
Yes, your Lordship, that they have told that if we
Madam,
settle
unilateral sending of a term of settlement will not suffice.
But Lordship, within next week, Lordship, kindly keep this in the next week, Lordship. Within
Or
next
today,
week.
next. And just sending mails will not help you. At 12. Non-conditional. Next page.
Non-commercial execution matters, item number 1.
My lord,
By after your lordships, under order dated 24th October 2025.
my lord,
Secured an amount of rupees 20 lakhs in the execution matter. Well, our section 34 application,
my lord, my
number
application.
section 38 of 2010. It is lying pending. You also kindly make take
Yes.
that up.
What is it? Execution, huh?
Yes, my lord. My lord, execution, my lord. They have deposited the sum, my lord.
Yes.
My lord,
20 lakhs.
90 lakhs. My lord.
Order was of 18 lakhs, my lord. They have deposited along with interest, entire interest.
My lord, that is where, my lord, it's 2010, my lord. It's been pending. So, my lord, I believe, my lord, section 34, my lord, may be heard.
My lord, I appear for the judgment debtor.
My lord, my lord, section 34, my lord, will be pleased, my lord, that,
Award is of which year?
my lord, 2010, my lord.
2010. Lord, section 34 is of 2010.
Award is of 14th of September 2010. Lord, we have complied with the last order so far as deposit is concerned, but I have an objection to the maintainability of this execution petition. This
section 34 year.
34 to on its merits.
So,
I'll come and show you.
my lord, it was directed, my lord, by
virtue of my lord's order 24th October 2020, Judge Chapter 11. My lord, in this, my lord, they had been directed, my lord, to, my lord, deposit the sum, my lord, of
Yes,
rupees.
I can see bank guarantee deposit within 3 weeks.
This has been complied.
It has been complied
On
with.
14th
It has been
November,
complied.
it has
That's, my lord, my.
Now tell me,
But
yes.
my lord, this
My lord,
execution
they will have to,
can't,
my lord, satisfy, my lord, whether, my lord, the execution.
execution can't stand today, my lord. This is a commercial division matter filed in non-commercial after the promulgation of commercial division in this court. It was filed in 2022. Commercial.
It can be transferred.
My lord, transfer is only when it has been filed. Section 15 doesn't provides for transfer of, my lord, cases which has been filed after enactment. Kindly reads, my lord, Section 15 of the Commercial Courts Act.
My lord has read all of this. My lord, I mean, as far as, my lord, this execution is concerned, my lord, I believe, my lord, now that they've deposited the sum, my lord, now the bank guarantee was to be unconditional to be renewed till disposal of the application. I believe, my lord, that they will have to, my lord, ensure. My lord, section, my lord, 34 may be heard by my lord, and my lord, then accordingly, my lord, we will, my lord, the AP number is 738 of 2010, my lord.
34 रख लेना सुनने के लिए इसके बाद.
Lord, Section 34 will be heard, my lord. It was filed.
My lord,
That has to be
738 of
transferred because
2000.
that was.
No, that will not have to be transferred, my lord.
Yes, that has to be transferred. It's a commercial division matter.
Oh, why is it listed then in the non-commercial?
This is what I've been saying, Lord. This is a commercial division matter filed in the non-commercial
No,
division. This has to go. Execution can't
no.
stand.
Thing goes. ये जो 34 है ना इसका 34 डाल दो इसको ये. हाँ कमर्शियल है. 34 तो कमर्शियल में ही होगा. तो एग्जीक्यूशन है.
हाँ.
I know. This is wrongly done, but वो तो वो कहाँ है? That's on the
34
commercial.
number touch.
34 is on the commercial side, right?
No, that is
34. That was filed in 2010, my lord.
That was
So,
filed in 2010.
2010, my lord.
But
So,
that has to go to the commercial division.
That has to go to the commercial. So we'll इसको last next वाले उसमें ना non-commercial Tuesday को इसको लगा दो.
Notification को देखा
Pass an order to get it listed in the commercial side.
Lord, will it be my Lord's pleasure, Lord, to consider this point, Lord, this
No.
maintainability that I've taken,
I mean,
Lord,
these
is
the absolute
clear cut
these
hit
points,
by section
my lord, they
15.
are government
They
company running away with our money, my
Yes,
lord.
what running away? I've
But, my lord,
deposited the
that-
money. I'm running away.
It be deposited.
Then, Lord,
But-
in that case, Lord, may there be a formal order so far as stay of the execution is concerned. Since I've complied with, I've deposited everything.
What stay do they require?
My lord,
Lord, there is an order
to the execution. I've
that
deposited the money.
On Tuesday, I'm listing the matter on the non-commercial side.
Yes,
yes.
Pass an order, put it on the commercial side, hear it and finish it.
Yes. Kindly notes the section 34 number.
The
Lord,
whole
one
one
line of
is
order will be helpful, Lord.
Learned counsel for the petition award debtor states that he has already deposited the money in terms of the order dated 24th October, right?
24th October 2025.
24th October 2025. List in the monthly list of September.
Monthly list of month September.
Lord, along with the section 34.
34 will hear.
Oh, very well. And Tuesday, Lord.
Well, section 34, my lord, 738 of 2010. I'm so grateful, my lord.
Great.
Where is
Lordship, I appear on behalf of the
My lord, I have taken time thrice.
Will issue warrant against him.
Lordship, a warrant has been issued against him on several occasions. Lordship, there was a specific direction on the Commissioner of Police of Bhubaneswar to execute the warrant. The warrant has not been executed yet. The Deputy Sheriff was supposed to file a report on that.
क्या रिपोर्ट है? Take down. Report of the Deputy Sheriff dated 29/7/2025. This 2025. After that, इस order के बाद क्या order है?
Lordship, the last order date was 9th April 2026.
This is a 25 report.
Copy W.
No report has been filed by the Deputy Sheriff. Deputy Sheriff is directed to place a report in terms of the order dated 9th April 2026 within a period of 2 weeks, list after 3 weeks.
Grateful, Lordship.
As a concern, no report is forthcoming. No report is forthcoming from the Deputy Sheriff. He is directed to comply with the order dated
Lordship, if the direction can be again,
9th April 2026 and file a report.
Lordship, if the direction can again be passed on the commissioner as well.
Let's see the report.
Lordship.
List after 3 weeks.
Item number 3, my lord. Yes, sir. Item number 3, I appear for the award holder, my lord. This is an award of 2015. We are in 2016. We could
your
not
voice is
realize
not
a
clear.
penny
You tell me.
from the judgment debtor.
The voice is not clear, Mr. Datta.
Yes, my lord. But can you hear me?
No, I can't hear you properly. Yes, tell me, what is it, sir?
Last occasion, they have directed to file submit a affidavit asset in respect of the award data award holder number 3, my lord.
Yes.
Award data number 3, my lord.
Yes, my lord. But can my lord hear me now?
I can hear you, Mr. Datta, but not very clearly.
Just let me log out and log in, my lord. Just a second. Let's log out and log.
And my lord, the examination going on.
Don't keep it next week. Next Thursday.
File করে দিন file হ্যাঁ
Next Thursday. Not today.
বলছি তো জমা করবেন না
Difficult.
Well, appear for the judge award holder.
Judgment data 4.
It's frozen. We can't even get out. Here.
For the award holder.
Judgment data 1 and 2. Lordship directed judgment 1 to come and for examination. Only difficulty is judgment data 2 is the wife of the judgment 1. She has gone through ovary some.
Judgment 1 was supposed to come.
No, yes, he can come. He
can come. He was supposed to come.
He's supposed to come. He came last week. Lordship bench was not there. Now only difficulty his daughter is not here. He has to take care of her wife. That's the only difficulty. For
So
that
next week, let him be.
next week, yes, he will be there.
Not today, not today. Next week. Let him be here next week.
I'm. Now 5. Sorry, 5.
You're,
Sorry. No, there is a confusion. Lordship. Yes,
you're in?
I am there.
You're in 4.
Yes, I'm in 4.
Okay.
You're in 4.
I'm in 4, my lord. That's a
I'm 4. There's some confusion. Yes, sir. Your
Uh,
Lordship.
judgment number 1 was supposed to be present for examination.
Yes,
Your Lordship, I'm led by my senior, Mr. Anuj Singh. He's on legs in.
Where's the judgment letter? Why is he
Lordship,
not here?
Lordship, due to medical conditions, is not present.
What? See, these grounds, unless and you move an application, I'm not going to hear these grounds. Why is not? Anyway, today is 3:30. I'll let you go. Next week.
But they're only killing time after. These are orders, my lord.
We will be there and we will
Next
move this
week you should be
application.
there.
Lordship, on the earliest we'll move this.
3:30. Your resolution is there. Yes. Wants to do it.
I have the judgment.
But now he was moving his own matter.
Okay. I apologize.
Judgment letter is here, right?
No.
Yes.
Judgment letter.
Somebody's here.
Judgment letter. is there.
judgment that
Which
is
one?
Item number
10, lordship.
Call out item 10.
Not 10.
Both
item number 7 also. He's here.
judgment debtors 2 and 3.
They are avoiding the process of the court.
This is item 10.
We'll take it. Somebody is here. That's why I'm taking it up. We'll take it next week. Who's here?
Item 10, Lordship, both judgment debtors 2 and 3, both are there.
Who's for the award holder? Item 10. Who's there, madam?
Lordship, I'm
Yes. You'll cross-examine them?
They're there, both.
Yes. You'll cross-examine?
item.
Put him on the stand. File देना 10 का. Give the file for 10. इसके पहले आपका कौन? नहीं. Your judgment date is not there. Why are you looking so perfect? शपथ पूर्वक कहता हूँ पुलिस शपथ लेके कहता हूँ दवाई के तौर पर see that sir, today is 3:30 your own resolution. जो कुछ भी कहूँगा सच कहूँगा सच्चे सिवा I'm taking it only because they have come. कुछ नहीं छुपा का नाम अरविंद भाव सिंह का BH
I have a resolution with me.
ARV V for victory IND भाव सिंह का BH AWSINGKA
पिताजी का नाम
राधा कृष्ण भाव सिंह का RADHA ARISHNA
उम्र
55 प्लस.
आप क्या करते हैं?
अभी तो कुछ नहीं करते.
आपका पता बताइए.
114 डॉक्टर LM भट्टाचार्य रोड मेट्रो हाइट्स हाइट्स HEIGHTS कोलकाता 14.
Are you acquainted with the award holder in this matter? Are you acquainted with the award holder in this matter?
Do you know the award holder? कोई award holder के बारे में पता है जो इस मुकदमे में आपके खिलाफ दायर किया है उसके बारे में पता है आपको?
थोड़ा
जैसे लेकिन
Can you tell me what do you know?
मेरा कंपनी आवरण फर्निशिंग मंत्रा प्राइवेट लिमिटेड था. वो NCLT में चला गया है. NCLT में चला गया था. हम उसका वन ऑफ आवरण AAWRUN N for नागपुर फर्निशिंग्स मंत्रा MENTRA प्राइवेट लिमिटेड
is converted into in the NCLT.
हाँ कंपनी NCLT में 2018 में चला गया.
Company NCLT in the year
2018.
What do you mean by NCLT में चला गया है?
Bankruptcy.
What do you mean by NCLT? Answer.
हाँ NP हो गया था मेरा अकाउंट.
My account, that is my account was NPA, non-performing asset.
Sorry? What did you say?
তিনি বললেন যে ওনার ব্যাংক অ্যাকাউন্ট মানে ওনার এটা NPA হয়ে গেছে, non-performing asset.
Okay. Is it correct that you obtained a loan of 45,000 from the award holder?
I do not remember the amount, but कुछ लोन लिया था. कंपनी लिया था, हम नहीं लिया.
The exact amount, but I have taken loan
My company.
from the company.
মানে कंपनी नहीं है, আমি पर्सनल नहीं है.
My company has taken a loan from the award holder.
Did you execute the personal guarantee in favor of the company? Respondent number 1.
I do not remember, but maybe don't remember. don't know the number, but possibly. But maybe.
Do you know that an arbitral award was passed against you for a sum of rupees 48 lakhs 33,000 and odd?
आपको पता है आपके जब आर्बिट्रेशन अवार्ड में जो आपके खिलाफ जाए वो अमाउंट है 48,43,000
अमाउंट याद नहीं है बट कुछ हुआ केस हुआ
I cannot remember the amount, but arbitration award cost is a unilateral appointment. How is it maintainable? How is it maintainable? Your client, move an application, not maintainable. One application, see my judgment on unilateral appointment. This goes, either you withdraw it or I'll dismiss it. What do you want to do? Take instruction.
Take instruction.
Come back next week, not today. Come back next week. And you read the judgment.
The right of turn I am ready.
Yes, sir, tell me.
Has been that is avoiding the process in Lordship has directed warrant of arrest. Police has not given any report.
Which item is this?
Lordship?
Which item?
7.
Item 7. Give the file.
But it's, you know,
You are appearing for the appearing for the award
holder. We both are
award holder.
once they have appeared.
Award letter is not appearing.
Once they have appeared and they have prayed before Lordship, they want to settle. That is only to mislead the court, nothing more.
So what do we do?
Kindly direct the one of the director who is making this, who has been named, warrant of arrest on that person. That is in GA2.
Has he appeared earlier?
They appeared only once.
You also didn't appear on the last date.
No. Last day there was a resolution, that is the no one.
Today also there is a resolution.
Okay.
Know that?
Okay, I don't know. Now, if you can see GA2, they have made an application for recalling of the warrant. They are not appearing, they are not cooperating, avoiding the process of law.
Where is the report of where does he stay?
In the GA2, they have said to recall the order of the warrant of arrest. This person, Ravindranath De, has been named in the GA2, is one of the directors. Warrant may be issued against him also.
Order, कोई है? Deputy Sheriff की report.
Page 4, para 8, Lordship, kindly see.
Just a minute.
Ravindranath De. They are blaming the blame upon this person. He is also a director. And these two directors are avoiding the process of law. Giving assurance to the court that they will cooperate. These are all false assurances. The award of 2017, 34 lakhs.
ये तो पुराना रिपोर्ट है, नया रिपोर्ट नहीं है कोई. This court wide, लिखो, take down, madam. This court wide order dated 25th July 2025 had issued warrant of arrest against the two directors, namely Rana Bhadra and Mr. Jagannath Devnath. Full stop. Till date, despite various orders, the warrant of arrest has still not been executed. The officer in charge / inspector in charge of the concerned police station as well as the superintendent of police having territorial jurisdiction of the said area are directed to ensure due execution and implementation of the said warrant in accordance with law. The superintendent of police of the concerned area shall file a report on the next date that despite various directions being passed by this court, no warrant of arrest could be executed. Explaining why the warrant of arrest could not be executed. The order shall be communicated to the concerned police station through the deputy sheriff. Full stop. Let a report be submitted before this court within a period of 4 weeks. Full stop. It is also noted that the respondent had moved an application GA2 for cancellation of the said warrant of arrest. They had appeared before this court on 29 January 2026 and had stated that they are exploring a possibility of an amicable settlement, and since then they had stopped appearing before this court. Full stop. Let this matter be listed after 4 weeks. GA2, none for the award debtor, dismiss for default. GA2 may order. Dismiss for default.
I'm grateful to you.
Yes.
The item number 18, my lord. My learned friend is also present, my lord.
Yes.
There was a direction to file them to affidavit of assets.
Against whom? Against him. Why not filed?
No, my lord, in compliance with the lordship order, I have prepared it, my lord, but unfortunately, due to rain, my lord, learned arguing counsel, he could not reach the court. I have the Xerox. Let it be, my lord, not today. Next week, we will positively file.
Next week, keep it.
And copy may be,
Let it be on record. That day we will serve now. I
Record
have the
what?
Xerox copy. Original is not with me. Next
So
week,
should I record that you have not complied with the order passed so and it was raining?
I will.
And your senior could not come.
My lord, I will place it before your lordship.
So that's why not today.
Not today.
What should I record? Your submissions?
No.
It's raining.
a copy may be served in the meantime.
I will.
Give advance copy to. Not today. Simply not. नहीं कुछ मत करो. Not. Just simply not.